Good morning. The time is now 9:30 and I shall resume this inquiry into the appeal made by Rainier Developments Limited, Samuel Gray and Robert Clark under Section 78 of the Town and Country Planning Act 1990 against the decision of Braintree District Council to refuse planning permission for an outline planning application, some matters reserved, for the residential development of up to 37 dwellings, including 40% affordable housing, with vehicular access, areas of landscaping and public open space. And that's on land to the west of the A131 High Garrett. This is the final day of the inquiry. Again, first, please can mobile phones be turned off or on silent, and desk phones as well. Yesterday, I heard from the appellant's landscape and planning witnesses, and then today there'll be two sessions. I'll undertake the conditions and planning obligations roundtable sessions. There'll then be an adjournment before I hear the closing statements, any cost claims before the inquiry is closed. As I stated in my opening comments, I request the closing submissions are made in writing beforehand. Again, there should be an attendance sheet circulating today, so please add your details even if you have not been present previously. In relation to the housekeeping matters, firstly, Mr. Williams.
Nothing from me, thanks, sir.
And Mr. Easton?
No, sir, thank you very much.
Okay, thank you. Okay, I'm now going to move on to the planning conditions roundtable session. The discussion is standard practice and does not indicate that I've made up my mind about the appeal, nor does it prejudice the position of the council. In terms of what I'll base our discussions on, I have a schedule which, well, the electronic file version anyway is dated the 18th of November. And that's been submitted to my case officer. Mr. Williams, you've got your hand raised.
Sorry, sir, just to be clear, Miss Banks is going to lead for the council in relation to the conditions. Could I just ask that she would check that she is, I've seen she's in the meeting, but if you could just turn her camera on and then perhaps lead on that. Sorry, sir, to interrupt.
No, that's fine. Mr. Eaton, who will lead for the appellant? Is it Mr. Murray Cox?
It's Mr. Murray Cox. I may jump in with what I hope are helpful comments as we go along.
And that version of the conditions, which is dated the 18th of November, I'm going to call that inquiry document 13. And obviously, I will have questions on some of the conditions, but I will run through obviously all the conditions, and I'll give an appropriate gap for parties to to raise comment. But if you do need to get my attention, Mrs. Banks, Mr. Murray Cox, please raise your hand. Okay, obviously starting with condition 1, and these are the details of the reserved matters which are to be submitted for approval. I did wonder why layout is not included within the condition. I wondered if one of the main parties could clarify whether that's just an omission or whether there's a particular reason. Mrs. Banks? Oh, you're on mute.
Sorry, I think that's an omission, sir. Sorry.
Okay, Mr. Murray Cox.
I was just going to say exactly the same.
Okay, thank you. Thank you. And then that condition goes on to specify when the reserved matters application must be submitted by, and also when the development must be commenced by as well. Okay, moving on to condition 2 then, which is the plans condition. In terms of the vehicular access plan, obviously revision P6 has been submitted now. So should that say revision P6, Mrs. Banks?
Yes.
Yes, and Mr. Murray Cox, would you agree?
I would agree with that, sir, yes.
Okay, condition 3 is landscaping. I wondered why, obviously landscaping is a reserved matter, so why that condition is included at this stage. Mrs. Banks, you have your hand raised, but I think it may be a legacy hand possibly, unless you...
Sorry.
It's
Yes,
okay.
I think ordinarily the council usually does put them on at the outline stage. I don't know why, but they do. I mean, if you feel it's inappropriate, you know, that can be safe for the reserve matter stage.
Mr. Murray Cox, any views on that?
No, I don't think we have any preference either way. I've seen these conditions applied both at outline and reserve matters stage, so we're happy to go with whichever approach you prefer.
Okay, thank you. And then condition 4, which is tree protection. This is to protect the trees, shrubs and hedges. Then moving on to condition 5, which is the construction environmental management plan, and this is to conserve protected and priority species. And then on to condition 6, which is the landscape and ecological management plan, similar reason to condition 5. Now on this, in terms of condition 6, I noticed it's called a landscape and ecological management plan. Are there any solely landscape elements in it? Or are they all kind of linked into the you know, the ecological management aspects of it as well?
Yes, they are. I think obviously some of the ecological features are included within you know, landscaping becomes part of it, if you see what I mean.
Mr. Murray Cox, do you have any views?
No particular views either way. I think it's a commonly accepted title for the document, and all the matters therein are regularly found referred to in such conditions on those documents.
Okay, thank you. I noticed part of the condition has a sort of part of it shown as a track change. So I was wondering if one of the main parties could explain that to me.
Yeah, should I do that, sir? This
Yes.
was an amendment put forward by the appellant. It's simply to add greater clarity to what that document should require, bearing in mind the matters set out in the application and the appeal material. My understanding, and no doubt Mrs. Banks will confirm, is that the authority doesn't consider that the change is necessary because it goes beyond what they use as a standard condition. As with previous conditions, we're happy to go with whichever approach you prefer.
Mrs. Banks, what's your view?
Only that our ecological officer, the condition is drafted in accordance with the British standard and has been accepted in this form by PINS on other decisions. That was the only issue. Okay, thank you. And my last point on condition 6. I just wondered when the measures in it would be implemented, whether it needs an implementation schedule or a clause within the condition. If there's one already in there which is inferred, please point it out to me.
So would that be point F?
Okay. Mr. Murray Cox, any views on that?
I think you're probably right. There should be an implementation trigger. I don't think it's quite right to say that's satisfied by point F. You might see that 2 paragraphs beneath that, the one just above the reason, says the approved plan will be implemented in accordance with the approved details, but it doesn't tell you when. So I think there should be something in there to tell all parties involved, or when those should take place.
Mr. Easton, you have your hand raised.
So yes, I do. I mean, in these sort of situations, because different parts of the plan may need to be implemented at different phases, I just wonder whether in the list of things that need to be submitted, we could add a timetable for implementation of the LEMP.
Okay, thank you. Mrs. Banks, any comments on that?
That's absolutely fine. Thank you.
Thank you. Okay, then moving on to condition 7. Just really for purposes of clarity, how does this differ from condition 6 in terms of what it intends to achieve?
So can I jump in, because
Yeah.
I can see that Mrs. Banks has her hand raised, and it might be that that question is best dealt with by Mrs. Banks. And I was going to raise a point which might be a silly point, but the third line of the condition refers to the CSA environmental ecological impact assessment. I've just checked my records, and obviously that drafting has been around the houses, so to speak, but I think the document was actually Tyler Grange.
Okay. And which Tyler Grange document was that, Mr. Murray Cox?
I think the title's right, it's just the author's name's wrong.
Oh, all right, okay. Okay, Mrs. Banks, do you have any views?
I have no problem if you feel it's a duplication or is already dealt with under condition 6 and wish to omit that. This is just something that's been requested by the ecologist, and it's gone through all the various people that have looked at it. I would be guided by you, sir.
Okay, thank you. And the last point of this question, again, I think the same point really as the previous condition in terms of the implementation. In terms of the implementation sort of schedule approach, as Mr. Easton suggested, do any parties have any views in relation to whether the same approach should be taken with this condition? Okay. Okay, thank you. Okay, moving on to condition 8, which is lighting, and again, this is for reasons related to ecology. In the first line of the condition, it makes reference to public areas. Just what would that encompass in terms of the developments itself, or what is that envisaging that this condition would cover?
It would be for public areas like parking, possibly street lighting as well.
Okay. Mrs. Banks, would it include, I mean, obviously sometimes people put lighting on their dwellings like security lights and so forth. Is it intended to cover that as well, or is it just?
I don't think it can,
no.
can it?
Okay.
No.
Okay. And Ms. Murray Cox, have any comments on that?
No, nothing to add on that, sir.
Okay, thank you. Okay, conditions 9 to 12, which concern ecology. I noticed that obviously there's 2 different versions of the conditions put forward by both main parties. So I think firstly, Mrs. Banks, if you could explain the council's approach.
The council's approach is for clarity in terms of discharging the conditions. With archaeology, they have to be often done in stages, and if it's all under one condition number, you can perhaps discharge only one part, and the rest is sort of could get missed. So we prefer them to be separated out for clarity during the discharge of conditions stage. And that's a preference as well from the county archaeologist.
Mr. Murray-Cock, in terms of the appellant's suggested condition?
So our alternative approach was simply to minimise the number of conditions, and on the basis that we felt you could wrap up all of the points in the authority's 4 conditions within one more concise version. We're not going to take a significant point over this. If you prefer the authority's approach, that's fine with us.
Okay, thank you. So, Mrs. Banks, looking at the 2 conditions, then, I mean, particularly looking at maybe the appellant's condition, does that cover all the matters which the council is concerned with in terms of archaeology?
Yes, I believe it does. The county archaeologist has seen it and has raised no issues. So yes, it does. But as I say, our preference is for it to be separate.
Okay, and likewise, Mr. Murray-Cox, in terms of the council's conditions, does that cover any matters which aren't covered by the appellant's condition?
Yeah, I've just had a very timely message from my client who's reminded me that the council's approach predetermines trial trenching will be required. That's condition 9, whereas our approach allows for geophysical analysis to be undertaken first. That was the only other point I think we needed to make.
Mrs. Banks, do you have any comments on that in terms of that approach? No, okay, thank you. Okay, moving on to condition 13, surface water drainage, the condition to prevent flooding. Then moving on to condition 14, which is highway works in relation to safety and accessibility. Obviously, at least some of these are off-site, and essentially, what's proposed is a Grampian condition. Obviously, we have covered this issue in detail and evidence in terms of the crossing points and footways and so forth. But does either main party have any further comments on that?
Nothing from our side, sir.
Okay. Then condition 15. Which is the travel plan for accessibility reasons.
Nothing from us.
And then 16, with condition 16, which obviously concerns the construction method statement, I did wonder whether is 16 and 17 one condition, or is there a particular reason why it's been separated into 2?
From my perspective, sir, it looks like it's something that could easily be dealt with as one condition, and I suspect that might have been the intention anyway, because there's only one reason given.
Yeah, okay. Mrs. Banks?
Yes, that's just what I was going to say. I think there's a sort of a layout error. I think that's supposed to have gone underneath K.
Okay. Then condition 18, which is concerns piling in relation to protection of living conditions matters. Is piling likely on this site? So maybe Mr. Murray-Cox, you may be able to provide some clarity on that, or is that the case?
It's probably not something I'm qualified to comment on. I think no doubt my client would message me if I say anything incorrect here. I think if there's a prospect that it might be undertaken and the council consider that in that scenario a condition would be necessary, then it's not unreasonable. I think my client has just messaged to say that I think piling is unlikely. If it is unlikely, then I think the condition is also unnecessary.
Okay, Mrs. Banks, any particular reason why the council would want to include a condition on piling? Is there a reason for it? Or?
Obviously, when the application is submitted and being considered, it's not known. So this condition is put on in the event that it is required. And if it's not, it can be ignored, or if you feel it should be left off, I have no objection to that, sir.
Well, Mrs. Banks, in terms of the evidence that the council's got in terms of piling, is there anything that the council has seen which suggests that piling might be required?
Not that I'm aware of.
Okay, thank you. Then condition 19, which concerns if contamination is found, and that's applied for pollution control related reasons. And then we have condition 20 concerning electric vehicle charging point, which again has been covered in evidence. I think that's related for reasons related to climate change and emissions.
Right.
Okay, well, that's all my comments on the conditions. Mrs. Banks, do you have any further comments to raise in relation to conditions?
No, thank you, sir.
And Mr. Murray-Cox.
Nothing more from me, sir.
Okay, well, that actually completes the roundtable session on conditions. Obviously, the intention now is to move on to the planning obligations session. Mr. Easton, obviously, when we discussed yesterday in terms of which of these two sessions should take place first, I obviously appreciate that a colleague was going to be in attendance at this session, and they weren't available until 10 o'clock. But I noticed there is a new gentleman has appeared on my screen. So is that the person in question?
Yes, so can I introduce to the inquiry Paul Wakefield, solicitor from Shakespeare Martineau, who is responsible for the Section 106 matters. And thank you for joining before 10 o'clock, Mr. Wakefield.
You're welcome, Mr. Easton. Good morning, sir.
Okay, so moving on to the planning obligations roundtable session then. Mr. Williams, for the council, who is intending to represent?
Thank you, sir. In terms of the compliance with the SIL 122 regulations, Ms. Banks will speak to that, and you should have had a SIL statement, client statement, lest there's any issues with that. In respect of the detail of the technical detail of the 106, unfortunately, the solicitors who were involved in drafting can't attend today from the council. If there are any technical matters, sir, technical legal matters about the drafting of the 106, if they're not resolved by Mr. Wakefield, obviously I'll be here as well, then that's a matter we might have to take up outside of this round table, but I'm hoping that won't be the case.
Okay, thank you. So in terms of the obligations, I'll need to assess those against tests that are set out in paragraph 57 of the framework, and also regulation 122 of the community infrastructure levy regulations. And so as both parties have already inferred, the two documents I'm going to refer to is the final draft section 106 agreement, and also the council's compliance statement. So if we can have those documents to hand, please. The obligations seek to address the council's second reason for refusal concerning the absence of a section 106 agreement, and I'll go through each of the obligations in turn. So Schedule 1 of the draft Section 106 agreement is the allotments contribution. And that is Schedule 6 in the compliance statement. And the compliance statement refers to policy CS10, the framework, and the Council's open spaces supplementary planning document. And it sets out why the contribution would satisfy the tests. And then the schedule in the draft final draft Section 106 agreement tells me what the contribution would be used for. Mr. Wakefield, do you have any comments on that?
No, none at all. So I think my client's position on the Section 106 is obviously they're content to meet the obligations set out therein. So I'm sort of here from a neutral perspective, as it were, in that regard. So.
And does the council have anything we should draw my attention in relation to this schedule?
No, thank you, sir.
Okay, Schedule 2 of the final draft Section 106 agreements is the outdoor sport contribution. And Schedule 5, the equivalent is Schedule 5 in the Council's compliance statement. And again, the Council's compliance statement refers to policies SP6 and CS10, the framework, the open spaces action plan, and the open spaces supplementary planning document. And again, it sets out why the contribution will satisfy the tests. Going back to the schedule in the draft Section 106 agreement, it sets out what the proposal could be used for, and that's under the essentially the meaning given under the outdoor sport contribution purposes. Is that list definitive, or if not, why is that?
So the projects that are listed in the list are taken from the Public Open Spaces Action Plan, which is published every year, and they are the most the projects identified within the Bocking North Ward. They're probably, yeah, I see what you're getting at. I think previous advice, we've always had to provide that information when the Section 106 agreement is drafted.
Yeah, I just wondered whether it says could include. So should it say would include? Is there a particular reason why it's not worded in that way?
I think we would prefer to keep could include, just in case there's for some reason those there's a reason why those particular projects can't go ahead.
So if I may on this, there's always a tension in these cases between the need for you to have sufficient certainty that the facilities or projects that the money was spent on are directly related to the development for the purpose of the SIL test, but also to allow a degree of flexibility such that if matters do change, that they can be spent on other facilities within the vicinity of the area. What I would submit is that so long you are satisfied that there is an identification of facilities which have a direct relationship with the impact of the appeal site, and that is what there's an indication of that within the 106, so that's sufficient for the 112 purposes. Of course, there are public law obligations on the council. It couldn't, consistent with its public law duties, go and spend that money on something wholly unrelated to the purpose of the contribution.
Okay, thank you, Mr. Williams. Mr. Wakefield, do you have any comments on that?
So if as I say, in terms of my instructions on this, we're content to proceed on the basis of the drafting. Obviously, if you would prefer that to be tightened up so that it's solely those items in the list, then my client would be content, I think, to accept that. But obviously, Mrs. Banks has indicated a desire to keep it as wide as possible to facilitate the council's requirements, and ultimately, so that's a judgment call, I think, for you in terms of its compliance with the SIL tests or otherwise.
Okay, thank you. Okay, I'm now going to move on to Schedule 3. And this is Schedule 7 in the Council's compliance statement. And Schedule 7 refers to the habitat regulations as well as policies CS6 and RLP 84, the framework and the supplementary planning document, which relates to the recreation avoidance and mitigation strategy. And again, Schedule 7 sets out why the contribution would satisfy the tests. Obviously, in this regard, I also have Natural England's response as a statutory nature conservation body to the shadow habitat regulations assessment report, which has been forwarded to the parties. One thing I did notice was the just going back to the schedule in the draft Section 106 agreement, that the list of protected designations under RAMS appears to be broader than that which is listed in the compliance schedule, and I just wondered if there is a particular reason for that.
I don't know the answer to that, to be honest with you, sir.
Okay. Mr. Wakefield, do you have any?
I'm afraid I don't know the answer to that one either, sir. I think that's the list that came through from the council, but I'm afraid I can't speak for the discrepancy between the two.
Okay. So Mrs. Banks, possibly should the compliance statement have reflected the list which is in this schedule in the draft Section 106 agreement? Is that where the issue is arisen? Or
it could be, yes, yes.
Okay.
I mean, our solicitor perhaps picked that up from the instructions and would probably be more fully aware of everything that needs to go into the agreement.
Okay, thank you. Obviously, so the main parties have seen the Natural England response to the Shadow Habitat Regulations Assessment reports. Mrs. Banks, do you have any comments on that response from Natural England? No. Mr. Wakefield, possibly Mr. Murray Cox might be more appropriate to answer that question.
No comments from me,
No.
sir.
Okay. Thank you. Okay, now I'm going to move on to Schedule 4, which is the final draft Section 106 agreement, which is the on-site open space and amenity areas. And that actually is also, I think, Schedule 4 in the compliance statements as well. And the Council's compliance statement refers to policies LP 38 and CS 10, the framework, the Open Spaces Action Plan, and again, the Open Spaces Supplementary Planning Document again. And again, sets out why the contribution would satisfy the tests. I noticed, Mrs. Banks, again, the compliance statement kind of refers back to some issues possibly related to the habitat regulations assessment in paragraph 5.5. So I think it'd be quite useful for the council to explain that, and if some of these measures are intended, you know, well, off-site.
No, I think paragraph 5.5 sort of covers the on-site mitigation in terms of providing a circulatory walk for dog walkers for the potential residents at the site.
Okay, so where it refers to partly off the site using the existing footpath networks, does that relate to the what is proposed under the Section 106 agreement, or is that what does that mean in this context?
Sir, if I can jump in there, I think the point there is that the signpost should refer to external footpaths rather than so it's the signpost on site shows off-site footpaths rather than any suggestion that the contribution is being directed to off-site works itself.
Okay, well, thank you for that clarification. That's very useful.
Thank you for that.
Okay, I'm now going to move on to Schedule 5 in the final draft Section 106 agreement. And that is Schedule 1 in the compliance statement. And the compliance statement refers policy CS2, and obviously the draft Section 106 would provide for 40% provision in accordance with that policy. And again, the compliance statement sets out why the contribution would satisfy the tests. And obviously, again, affordable housing is a matter that's already been covered in evidence. But Mrs. Banks, any further comments that you'd wish to raise on this schedule?
No, thank you, sir.
And Mr. Wakefield.
So only to say that I think since the version of the Section 106 which was submitted to you, I think there's been a couple of typographical changes to the definition of the chargee and a couple of other provisions. Nothing substantive, but for your benefit, I don't know whether it would be helpful at the conclusion of this to send you through a track change version of the varying typographical bits and pieces that have been picked up, just so that you've got a record of that, so that when you get the final version, you'll see that matches up to the update rather than the iteration from 2 weeks ago.
Yeah, I think, Mr. Wakefield, I'm happy just with the final version to be submitted after the inquiry. Thank you.
Very good.
Okay, I'm moving on to Schedule 6, which is the library contribution, and that's Schedule 3 in the compliance statement. And again, the compliance statement refers to policy SP6 in the framework and sets out that the contribution will satisfy these tests. And then in this instance, the schedule in the draft Section 106 agreement tells me precisely what the contributions would be used for. Any further comments on that, Mrs. Banks? No, Mr. Wakefield?
No, sir.
And then the last contribution, which is the last schedule, which is Schedule 7 in the final draft Section 106 agreement, that relates to the education contribution, and that is Schedule 2 in the compliance statement. And the compliance statement refers to policy SP6 and the framework and sets out why the contribution will satisfy the tests. And then the Schedule 7 itself in the final draft Section 106 agreement includes contributions for early years and childcare and also primary education as well. Again, maybe this may be a similar point to what Mr. Williams has previously raised, but I do notice that the schedule in the draft Section 106 agreement does not actually specify which early years, childcare and primary education facilities the contribution will be spent on, although it does state a 3-mile radius amongst other criteria. So again, just quite useful for me to understand the council's approach in relation to that, Mrs. Banks, or possibly Mr. Williams.
Presumably it's to again allow some flexibility.
So yeah, it's a similar point to the point I made previously. The approach of applying that 3-mile radius gives you some comfort that the monies spent will be related to the impacts of the site. I'm just looking at the SIL notes now. Maybe Ms. Banks can help me whether it identifies specific facilities on where that money may be spent. I don't know whether I don't know whether you've included that information, Ms. Banks, or if not, so whether that's information that we could provide to you so that you can be satisfied that there are locations within the 3 mile radius that money would be contributed towards.
Okay, thank you. I mean, is there any dispute between the parties that there are such facilities within a 3 mile radius, Mr. Wakefield?
I'm looking to Mr. Murray Cox to hopefully chip in at this point, sir. But I don't believe there's any dispute between. I'm certainly not aware of any dispute between the parties on that front. I think, as I say, my client is content with what's in here. I think the rationale, as I understand it from the county council, in terms of their desire to have as much flexibility on this, is because pupil numbers fluctuate on a year-by-year basis, and as a consequence, they don't quite know when this money is going to filter through, and therefore where the need is going to fall in terms of which local primary school it happens to be, or which early years centre it happens to be.
Just added to that, my experience in other inquiries is of course that sometimes the need actually isn't in the school to which the children will directly, of the appeal site will directly go to, but they displace children that would otherwise have taken those places and cause a knock-on effect to other schools. And so I have had these type of sessions where there's been evidence of particular need within a particular school, but also of a more general need within the area. As I say, so that, I mean, we know from the accessibility evidence that there are schools, including primary schools, within the 3 mile radius. I appreciate, so I don't think you have any particular evidence before you about their capacity or the need. If you need that information, that's something that the council might be able to provide in due course. But I would hope, if there's no dispute about it, that the provisions within the 106 are enough.
Okay. Does your panel have any further comments on that before I move on?
No, sir.
Okay, thank you. Okay, well, that's all my comments on the draft final section 106 agreements and the compliance statements. Mr. Wakefield, you got your hand raised.
Well, only insofar, sir, as to say, obviously from our perspective, I'll just draw your attention to clause 2.8 of the document, which is the sort of the blue pencil clause therein. When it comes to determining the appeal, I just draw your attention to the wording of that clause in terms of how you phrase any decision in relation to the planning obligation, sir.
Okay, thank you. And does the council have any other comments it wishes to raise? Mr. Easton, you've got your hand raised.
So you may have come to this in any event, but it's just a practical question which we mentioned yesterday. Mr. Wakefield wasn't here when I raised the point. Would it be acceptable if we provided to you and the council an executed version of the section 106 within 14 days?
I'll come on to that in a minute, Mr. Easton. That was my kind of last point in terms of dates. Yeah, but just has the council got any final comments you wish to raise on the documents itself? Mrs. Banks?
No, thank you.
Okay then. Well, in terms of setting a deadline, my original intention was, and obviously the inquiries may have gone on slightly longer than possibly was originally envisaged. My original intention was the 10th of December, which would be, I think, a week on Friday. Would that be sufficient, Mr. Easton?
So that's possibly not a question I can answer. It's a sort of question that's possibly above my pay grade. I will just double check, because sometimes there are practicalities involved in actually getting the relevant people to sign the document. And so I'm just waiting for instructions. I mean, in fact, Mr. Wakefield might know the answer to this, but if not, we'll get a clear instruction from our client as to whether or not the 10th of December is workable. I mean, just while I'm receiving this, save for the typographical amendments that Mr. Wakefield's already mentioned to you, the document won't change, and so I don't see how it would prevent you from reaching a decision, because you're not waiting for any substantive changes which may affect the way in which you resolve the issues between the parties on the appeal.
So I think in terms of the mooted timescale, my only concern is more in relation to how quickly both councils can seal documents, because certainly my experience of the last 18 months has been that local authorities are sealing documents on a less frequent basis than might otherwise be the case in a pre-pandemic world, and therefore at some points it's once a week, and if you miss one date, you're stuck in a kind of week-long cycle. So I think the more time you can give the local authorities to seal the documents, the better. Obviously, if the 10th of December is your absolute drop dead date, sir, then the 10th of December is your absolute drop dead date, sir, and the councils will have to work to that.
Okay. So
I've been asked whether we could entice you to go with the 15th of December, which isn't a significant period of time, but I think it gives us a degree of flexibility that means that we'll be able to get everything done by that date.
Okay. Mrs. Banks, have you got comments to make on the terms of the 15th of December date? Does that council have any points she wishes to raise on that?
No, thank you.
Okay, fine. Well, I will set a deadline then of the 15th of December. But say if the final version, executed version, not been provided by that time, I will proceed, to make a decision. Okay, well that completes the planning obligations roundtable session. So obviously I now propose to adjourn the inquiry, and we are going to resume for closing statements. Now, in terms of when we're going to resume, obviously we discussed yesterday having a longer break than normal, to enable the advocates to finish off their closing statements. Looking at the timings as well, I wondered if we'd said 1 o'clock, whether that would be that's essentially the time I'm considering. Mr. Williams, any comments on that?
So I'm very happy with that. I'm very close to finishing it. Just needs my client to have a read through and approve, and I'd hope they'd be able to turn that round in that time. I'm in nods, Mr. Banks.
Mr. Easton, 1 o'clock. Any comments on that?
Entirely happy with that, sir. Thank you.
Okay. Well, the time is now 10:17. So I will adjourn the inquiry until 1 o'clock. Thank you. time is now 1 p.m. and it's time for me to resume this inquiry. Since the adjournment, I've received from the appellant, from Mr. Easton, a further Court of Appeal judgment, which I understand Mr. Easton will refer to in closing. So I'm going to call that inquiry document 14. I've also received the council's closing submission in writing, which I will call inquiry document 15. And I've also now received the appellant's closing submission in writing, which I'm going to call inquiry document 16. Okay. May I ask the council's advocate to make a closing statement?
Thank you very much, sir. So the closing submissions on behalf of the council address each of the main issues that you identified, both in your CMC and at the beginning of this inquiry, and I address them in turn, starting with a suitable location for housing. Residential development of the appeal site is contrary to the spatial policies of existing and emerging development plan policy. The conflict operates at two levels. Firstly, the appeal site lies outside of settlement boundaries and is not an appropriate countryside use. And secondly, a proposal for significant residential development at High Garrett is inconsistent with the spatial strategy for the area. I deal with those points in turn, starting with the settlement boundary policies. The appeal site lies outside of settlement boundaries in the countryside. RLP2 of the adopted local plan confines new development to within settlement boundaries, save for specific exceptions. It's common ground that none of the exceptions apply, and therefore the proposal is contrary to this policy. Similarly, CS5 of the core strategy directs new development, except that which is appropriate to the countryside, to areas within settlement boundaries. Again, it's common ground. The proposal does not constitute an appropriate use in the countryside, and it's therefore also contrary to this policy. The emerging Section 2 local plan, policy LPPP1, takes the same approach as policy CS5, confining development outside of settlement boundaries to uses appropriate to the countryside. Mr. Murray Cox accepted, rightly, that the proposal was contrary to this policy. Notwithstanding the conflict with existing and emerging settlement boundary policies, the appellant contends that there's overall compliance with the spatial strategy for the area, as well as with the development plan as a whole. The appellant's case in this regard turns on their interpretation of policy SP3 of the Section 1 plan. In short, as I understand it at least, it's their case that any proposal which adjoins any existing settlement will be consistent with policy SP3, so long as, on a case-by-case basis, the decision-making concludes the settlement is appropriate for the development proposed, having regard to its scale, sustainability and existing role within the district. The appellant's interpretation does not withstand scrutiny. It isolates one sentence from the text of policy SP3, ignores the remainder of the policy wording, and fails to have regard to either the objective of the policy or its context. The proper approach to the interpretation of development plan policies was summarised by Lord Justice Lindblom in the Gladman case, where he said, I'll cite from paragraph 22, the interpretation of development plan policy, however, is ultimately a matter of law for the court. The court does not approach that task with the same linguistic rigour as it applies to the construction of statute or contract. It must seek to discern from the language used in formulating the plan the sensible meaning of the policies in question in their full context and thus their true effect. This context includes the objective to which the policy is directed, other relevant policies in the plan, and the relevant supporting text. The court will always keep in mind that the creation of development plan policy by a local planning authority is not an end to itself, but a means to the end of coherent and reasonably predictable decision making. When interpreting policy SP3, it's therefore necessary to have regard to the following. First of all, sir, the context of the Section 1 plan. Policy SP3 is a policy within the North Essex Authority's shared strategic Section 1 plan. As the supporting text recognises, the Section 1 plan concerns strategic matters with cross-boundary impacts in North Essex. In contrast, it's the Section 2 of each plan, which contains the policies and allocations addressing authority-specific issues. Secondly, the objectives of the Section 1 plan. The objective of the Section 1 plan was to articulate the strategic priorities of the wider area and how these priorities will be addressed. This included the effective delivery of planned strategic growth, particularly housing. In particular, the main purposes were to include to articulate a spatial portrait of the area, including its main settlements, as a framework for accommodating future planned growth, and B, to provide a strategic vision of how planned growth in North Essex will be realised. It was these policies which policy SP3 sought to achieve. Quite clearly, sir, the delivery of planned growth. Thirdly, supporting text to policy SP3. The supporting text notes that new homes will be accommodating as part of the existing settlements according to their scale, sustainability and role, but importantly goes on to explain that for the majority of settlements, these issues are addressed in the second section of the local plan, dealing with each authority's area. The spatial context of North Essex area is then set out in the supporting text as it relates to the main settlements, which unsurprisingly did not include High Garrett. Fourthly, the text of policy SP3 itself, and of course, just adding to my text here, of course, the text of the policy itself is of fundamental importance. But I say that the text of the policy is consistent with the context, being the supporting text and the objectives, and supports the interpretation advanced by the council. And I say for that for the reasons I advance in my text. Because it's important to have regard to the whole of the policy wording beyond the words which the appellant seeks to isolate. SP3 provides that development will be accommodated within or adjoining settlements according to their scale, sustainability and existing role. The text which the appellant seeks to rely on. But that begs the question, sir, who is to determine which settlements are suitable to accommodate development according to these factors? And what is the forum for doing so? The appellant's case is that this determination is to be made within the development management context on a case-by-case basis. That not only reads words into the policy which do not exist, it ignores, as Mr. Murray Cox had, the policy SP3 actually answers that question only 2 paragraphs later, explaining that in section 2 of its local plan, each local planning authority will identify a hierarchy of settlements where new development will be accommodated according to the role of the settlement, sustainability, its physical capacity and local needs. Thus, policy SP3 itself is explicit. It's for the local planning authority, through their section 2 plans, to identify which settlements will accommodate growth within or whether within existing boundaries or adjoining. Then fifthly, other policies. The appellant's interpretation also brings policy SP3 into tension with policy LPP1 of the section 2 local plan, as Mr. Murray Cox acknowledges. Given the section 1 and section 2 plans make up 2 parts of the same local plan, which were prepared and submitted for examination at the same time, and which are designed to work in harmony, it would be surprising, to say the least, if there were an internal conflict between them. The reality is that when SP3 and LLP1 are interpreted properly, there is no such conflict. SP3 of the section 1 plan establishes the framework for planned growth. The planned growth is then realised through the spatial strategy and allocation of the section 2 plan, which include new development accommodated within and adjoining settlements. LPP1, so that should say, then applies to any unplanned development outside updated settlement boundaries. Seen in context, having regard to the objectives of the policy as well as the supporting text, it's clear that policy SP3 is a strategic policy which sets the framework for future planned growth, including planned housing growth, across the entirety of the North Essex area, but specifically as it relates to the main settlements. It's in that context that the language of the policy itself tells us that it's for each planning authority, each local planning authority, through their individual section 2 plans to identify where new development will be accommodated according to the role of the settlement, sustainability, its physical capacity and local needs. It is therefore through the section 2 plan that individual local planning authorities may choose to provide for future planned growth by way of allocations or specific policies within or adjoining settlements. Once it has done so, policy LPP1 applies to development outside those boundaries. Contrary to the appellant's interpretation, policy SP3 is simply not directly relevant to non-strategic, unplanned housing applications, which happen to adjoin the boundary of any existing settlement within the North Essex area. On a proper interpretation, therefore, SP3 does not serve to undermine the fact that the proposal is contrary to both existing and emerging settlement boundary policies, and as a consequence, contrary to the spatial development policies of the development plan. Turning then to the second element of this topic, the spatial strategy for the area. Quite apart from the application of settlement boundary policies, it's clear that a proposal for significant residential development at High Garrett is inconsistent with the spatial strategies of both existing and emerging local plans. Save for their contention in respect of policy SP3 addressed above, the appellant does not contend the proposal is consistent with the spatial strategy of the existing development plan. They were correct not to do so. The adopted local plan seeks to concentrate new development on the towns of Braintree, Witham, and to a lesser extent, Halstead. And similarly, the core strategy's spatial policy statement indicates that the majority of new development and services will be concentrated in the main towns of Braintree, Witham, and Halstead, and at the new and identified growth locations and in key service villages. This plainly does not include directing development towards High Garrett. Nor does the spatial policy of the emerging Section 2 local plan promote growth at High Garrett. It provides, as proposed to be amended by the main modifications, that the broad spatial strategy for the Braintree district should concentrate development on the towns of Braintree, Witham, and the A12 Great East Mainline Corridor and Halstead. Moreover, in accordance with the framework established in SP3, the emerging Section 2 local plan establishes a hierarchy of settlements, identifying where development will be accommodated and where it will not. The evidence which underpinned this assessment is explained in the main Matter 2 statement. Whilst the Section 2 plan envisages development being considered sustainable within key service villages and small-scale development potentially being considered sustainable within second-tier villages, in respect of third-tier villages, which are the smallest villages in the district and lack most facilities required to meet day-to-day needs, the Section 2 plan explains that the tests of sustainable development will not normally be met. The Council has identified High Garrett as a third-tier village. It's noticeable the examining inspectors have approved the main modification consultation without any suggestion that it's inaccurate. They were plainly correct to do so. On any account, High Garrett is a small village, which of itself lacks the facilities required to meet day-to-day needs. Mr. Grist confirmed as much during his cross-examination. Conclusions then on the sustainability of location and the weight to be afforded to this factor. The application of existing and emerging development plan policy demonstrates unequivocally that the appeal site is an unsuitable location for residential development. It also follows that, given the centrality of these policies, the proposal is in conflict with the development plan as a whole. Now, the appellant suggests that the weight to be given to settlement boundary policies should be reduced for three reasons. Firstly, the boundaries are not drawn to meet existing needs. Secondly, the restrictive policy approach employed is contrary to the MPPF. And thirdly, there are inconsistencies between settlement boundary policies and policy SP3 of the Section 1 plan. Again, none of these contentions withstand scrutiny. First, the emerging Section 2 local plan seeks to meet identified housing needs in full for the period 2013 to 2033. Indeed, it provides a healthy headroom in excess of the identified needs, 14% above the residual requirement, to allow for a degree of flexibility. As part of the evidence base for the Section 2 local plan, the settlement boundaries were reviewed and amended to ensure they are able to accommodate housing and other needs until the end of the plan period. This policy approach, together with the evidence underpinning the settlement boundaries and the ability to meet housing needs, has been tested at the recent local plan examination. It is of some note, therefore, that the inspectors examining the Section 2 local plan have recently approved the main modifications of the Section 2 local plan for consultation, none of which cast any doubt on the ability of the Section 2 plan to meet its needs in full, nor on the soundness of settlement boundary policy, nor, for the purposes of this pill at least, which make any material changes to the settlement boundaries in the emerging plan. Nor was it suggested that any further sites are needed to meet existing housing or other needs. Second, as a matter of principle, there's no inherent conflict between the settlement boundary policies and the policies of the MPPF. Settlement boundary policies are a regular feature of post-MPPF development plans. They are an appropriate mechanism for implementing spatial strategies of development plans. As the emerging Section 2 plan explains, they provide a guide where the Council believes new growth should be directed. In particular, we say they're consistent with the requirements of national policy to firstly promote an effective use of land in meeting the need for homes and other uses while safeguarding and improving the environment, paragraph 119, and to recognise the intrinsic character and beauty of the countryside, paragraph 174b. Now, the appellant argues that the restrictive nature of the policies is not fully in accordance with the framework, and they rely on the Gilded Terrace decision, amongst others. However, the restrictive nature of settlement boundary policies only becomes an issue if the boundary is not predicated on meeting existing needs, as the inspector in Gilded Terrace recognised. As explained above, the settlement boundaries have been reviewed as part of the Section 2 local plan, and the Council have concluded the existing need, indeed that running to 2033, can be met without needing to amend the settlement boundaries so as to accommodate the appeal site within them. And I should say, sir, that since the Gilder Terrace decision, certainly since the hearing, there have been the hearings of the examination hearings, and importantly, the approval by the inspectors of the main modifications for consultation, which give a clear indication that the examining inspectors do not consider that any further sites would be needed to meet the existing needs in full to 2033, nor that there would need to be any further relevant changes to the settlement boundaries. Thirdly, for the reasons outlined above, when interpreted correctly, there is no inconsistency with policy SP3 and development boundary policies. Now, the Council acknowledges the Section 2 plan is still in the course of being examined. It has, however, been through the examination hearings and main modifications have been approved without there being proposed any significant amendments to either the settlement boundary policy or the spatial strategy, nor has there been any indication that further sites are needed to meet housing needs to 2033. If any of these matters have been a concern to the examining inspectors, it would have been expected that they would have required the Council to undertake further work. They would have not approved the main modifications for consultation. Now, with respect to Mr. Murray Cox, he appears to have misunderstood the purpose of a main modification consultation. The current consultation, that is the main modification consultation, is focused on the proposed main modifications, not on the plan or its policies writ large. That consultation took place at the Regulation 19 stage and was subject to debate at the examination hearings earlier this year. For example, with respect to policy LPP1, the proposed wording change, in particular that from strictly controlled to defined, is a main modification which is subject to consultation. But the broader policy itself, including its soundness and consistent with the NPPF, has already been the subject of a Regulation 19 consultation and lengthy examination. This is not the subject matter of the focused main modification consultation. In conclusion, given the fundamental conflict with both the settlement boundary policies and the spatial strategy of existing and emerging development plans, but whilst recognising the second plan is still in the course of examination, the Council contends that the unsuitability of the appeal site in policy terms should be given moderate weight. As the next main issue illustrates, the application of national policy also identifies the appeal site as an unsuitable location for housing. And I turn to that topic, accessibility and sustainable location. National policy requires that significant development should be focused on locations which are or can be made through sustainable, through limiting the need to travel and offering a genuine choice of transport modes. It's common ground that the appeal site constitutes significant development to which this imperative of national policy applies. Consistent with its categorisation as a third-tier village, there are no facilities in High Garrett itself which would enable future residents to meet their day-to-day needs. Mr. Grist accepted much as in cross-examination. Walking. Having facilities for day-to-day needs within a walking distance of most residents is a key component of sustainable location. The transport statement for this proposal, approved by Mr. Grist, implicitly accepted as much. The propensity for people to walk to facilities is affected by several variables, chief amongst them being distance and quality of the route. Neither variable is favourable to this appeal site. Distance. Only 2 months ago, an inspector dismissing an appeal concerning the site immediately to the south, Thistlefield, concluded that the walking distance from the site to facilities and service in Bocking would be prohibitive. He was plainly right to do so. That the distances involved would be prohibitive for the majority of future residents of the site is clear from the application of the standards of the IHT guidance. This guidance, which Mr. Grist rightly marked out as being of importance, is the most finely grained authoritative guidance available as to the acceptability or otherwise of walking distances to a variety of facilities. The IHT guidance provides 3 categories of acceptability for a variety of facilities: desirable, acceptable and preferred maximum. As Mr. Grist accepted, this recognises as a generality, A, the further people have to walk to access facilities, the less likely they will do so, and B, that people may have a greater tolerance for walking to certain facilities than others. It's a reasonable assumption that fewer people will choose to walk to facilities which are within the acceptable range than the desirable range, and still fewer will walk within the preferred maximum range. Even on the appellant's reading of Table 3.2, which ignores that the table specifically gives an acceptable distance for each category of facilities, facilities which fall above the preferred maximum distance are an unacceptable walking distance away. Applying this guidance to the main facilities in Bocking is instructive. Firstly, in respect to the nurseries. Both nurseries fall well above the desirable and acceptable ranges. Agnes Day falls within the preferred maximum range, but towards the upper end of that range. Scallywags is well above the preferred maximum. When it's considered that visitors are likely to be parents accompanying small children, with or without pushchairs, then these distances will be prohibitive for most. Secondly, the primary school, 10 metres within the preferred maximum. The primary school falls well above the desirable and acceptable ranges and just within the preferred maximum. Again, when it's considered that primary school with children from the age of 4 to 10 years old, the distances for the vast majority will be prohibitive. Retail. The relatively small co-op in Bocking is the closest retail shop which will provide day-to-day needs. Applying the standards applicable to town centre facilities, which is the most appropriate category given the retail is a town centre use, the co-op lies over 2.5 times above the preferred maximum distance. Applying average walking speeds, it would take virtually an hour, not including the time for shopping, to walk from the appeal site to the co-op and back. This is before encumbrances such as shopping are accounted for, carrying shopping are accounted for. At this distance, there is virtually no prospect of any future residents of the appeal site walking to the co-op on a regular basis. Restaurants. These 2 restaurants in Bocking, one of which is a takeaway, are over twice the preferred maximum distance for town centre facilities. Again, the most appropriate category to use. Again, there is very little prospect of the appeal site, residents of the appeal site walking to the restaurants in Bocking. It follows that Mr. Grist's reliance on the AHT standards in support of his case is wholly misplaced. To the contrary, these standards demonstrate unequivocally that on the basis of distance alone, residents of the appeal site will be most unlikely to walk to the facilities in Bocking, at least on any regular basis. The other guidance and data referred to by Mr. Grist does not alter this conclusion, taking them in turn. Firstly, the Manual for Streets. The Manual for Streets promotes facilities being within 800 metres or 10 minutes walking distance, which, they say, residents may access comfortably on foot. Mr. Grist accepted there are no facilities which provide day-to-day needs which are within a distance which, by this measure, residents may access comfortably on foot. Facilities in Bocking are all over twice this distance away. Whilst the Manual for Streets does repeat guidance which was previously included in the PPG 13, this must be read together with the more finely grained IHT guidance, which explains that 2 kilometres is the preferred maximum for some facilities, but well above the preferred maximum for others. Secondly, the National Travel Survey statistics. Albeit no doubt unintentionally, Mr. Grist's reliance on the NTS's statistics is and was misleading. First, his contention that it can be deduced from the fact that because the average trip length for 5 to 10-year-olds is 1.8 miles, walking to the primary school is a realistic choice for residents of the appeal site, is flawed. As Mr. Grist accepted, he had ignored that the average trip length in question was not an average walking distances, but an average of distances of trips by all modes of transport, including car and bus, and up to distances of 50 miles. Thus, the statistics tell us nothing about the propensity of young children to walk 2 kilometres to and from school. Secondly, his reliance on the fact that 1/3 of journeys between 1 and 2 miles are undertaken underfoot ignores, firstly, the fact that the data, as he accepted, includes walking for recreational purposes, i.e. rambling, and secondly, that a resident of the appeal site who wished to walk to the facilities in Bocking, for example, to drop off their children at school or to pick up a loaf of bread, would have to walk there and back. Thus, a round trip to the co-op is not between 1 and 2 miles, it's approximately 2.7 miles. And as the NTS survey shows, only approximately 4% of trips over 2 miles are undertaken on foot. And of course, I emphasise that includes walks for recreational purposes, rambling. Turning then to the quality of the route. As the Manual for Streets recognises, the propensity to walk is influenced not only by distance, but also by the quality of the walking experience. The IHT guidance develops this by explaining that if people are to choose to walk rather than drive, at least for short trips, the pedestrian environment must be more than just functionally adequate. It needs to be of high quality, so the walk is a pleasant experience. In addition to the distances involved, the walking experience from the appeal site to Bocking by the A131 would act as a significant disincentive to walking this route. The A131 is by any measure a busy road. It is generally free flowing with traffic on the road regularly travelling at the speed limit, 40 miles an hour. As Mr. Grist agreed, and as would be obvious from any site visit, it is regularly used by HGV traffic. It is, truth be told, exactly the type of busy road which the Manipur Street says would make a 20-minute walk seem endless. Of course, in order to reach Bocking, residents of the appeal site would not simply have to walk alongside the A131, they'd have to cross it on 2 separate occasions, as well as once crossing Church Street. The manual for streets recognises that streets with high traffic speeds can make pedestrians feel unsafe, indicating that where speeds are above 20 miles an hour in residential areas, pedestrian activity can be displaced. This guidance reflects the fact that whether or not there's an actual safety risk, high traffic speeds can cause a perception that route is unsafe. In this instance, the need to cross a busy highway on a number of occasions will further deter future residents from walking the route beyond the simple distance and general unattractiveness of the route. So I should add this one point. There is, of course, a public right-of-way route by which the residents of the appeal site could access Bocking. But as Ms. Banks points out in her evidence, that's not a reasonable alternative for residents accessing Bocking for their day-to-day needs, for instance, going to the shop or dropping their children off at school. It's a circuitous route to some degree. It's certainly a longer route. It's not lit or paved. And so whilst one may choose to ramble along it for recreational purposes on a stroll on a Sunday perhaps, it's not going to be regularly used for accessing the facilities in Bocking. Turning then to cycling. As the Manual for Streets recognises, cyclists are particularly sensitive to traffic conditions. High speeds or high traffic volumes of traffic tend to discourage cycling. The A131 has both high speeds and high volumes of traffic. What is more, because of its location, there is no way of cyclists wishing to travel to or from the site being able to avoid travelling on the A131. Mr. Grist accepts this. It is why, no doubt, he only suggests that confident adult cyclists would be able to take journeys by this mode. In cross-examination, he indicated that very hardened cyclists may choose to cycle to and from the appeal site. The reality is that for the vast majority of residents, cycling will not offer a realistic alternative to the private car for day-to-day journeys. Bus provision. It's recognised that the bus provision is reasonably good for a relatively rural area, and the bus stops are in close proximity to the site. However, the need to cross the A131 to travel south towards Braintree will act as a real disincentive to some, for example, parents with young children or elderly relatives. In any event, the bus provision does not come close to outweighing the complete lack of accessibility by foot or cycle. Home working and electric vehicles. The emphasis placed in the appellant's opening submissions on the facilitation of home working and low or zero emission vehicles betrays the reality of the situation, that the appeal site is not in a sustainable location for significant development. Of course, the MPPF encourages the provision of both broadband and electric charging points, but it does so in addition to requiring significant development is focused on locations which are sustainable, not in lieu of it. And it cannot properly be maintained that the provision of broadband, which Mr. Grist confirms that Openreach will provide to new housing developments of over 20 homes free of charge, or electric charging points, which are a common feature of new residential developments, can turn an unsustainable location into a sustainable one. To the extent that the provision of these facilities is relevant at all to the issue of accessibility, which is at best tenuous, they can be only given limited weight. Conclusion then on the sustainable location issue. The field inspector was right to find that occupants of the proposed housing would be primarily reliant on private transport and that the location has substandard access to local services and facilities. The evidence of this inquiry has demonstrated unequivocally that High Garrett generally and the appeal site specifically is a wholly unsustainable location for significant development. This is an important consideration in the context of this case. It means the proposal is in conflict with the imperatives established in national policy and the development plan. But it also means, Mr. Murray Cox agreed, that even on the appellant's own case, and even applying their interpretation of policy SB3, the proposal is contrary to the spatial strategy for the area, as well as the development plan as a whole. And that is, to be clear, because even on their interpretation of policy SP3, the decision maker has to consider whether the development is sustainable. And plainly it is not. Indeed, as Mr. Murray-Cox very fairly accepted, the appellant has not advanced a case that if you, sir, agree with the council that the appeal site is not in a sustainable location, the planning permission should nevertheless be granted. He was right to take this approach. The unsustainable location of the appeal site for development of this scale and the allied conclusion, even on the appellant's approach, that the proposal is contrary to the development plan and its spatial strategy, is enough to justify refusing permission on its own. The benefits of the scheme, to which I'll come, do not come close to outweighing the harm from permitting development of this scale in an unsustainable location, contrary to the spatial strategy of the development plan. This holds true even if the tilted balance is engaged. I turn next to the effect on the character and appearance of the area. It's common ground that the proposal will have an adverse impact on the landscape character and visual amenity of the area. The difference between the parties is one of degree, starting with the landscape or townscape harm. The appellant's conclusion that there will be limited landscape harm is an underassessment of the degree of adverse effect that would be caused. In particular, the appellant ignores the contribution the appeal site, as an undeveloped arable field, makes to the character of the area, including the character of High Garrett, and therefore they underassess the degree of harm that would be caused by its development for housing. As Ms. Brockhurst readily accepted, the western side of the A131 has a very different character to the eastern side. The eastern side is characterised by predominantly linear housing development fronting onto the road. It is a continuous, unrelieved form of ribbon development which Miss Brockenhurst described as having a harsh character. It is unmistakably urban in character. In contrast, the character of the western side of the A131 is less harsh, far less urban of an urban character. Whilst there is built development in places and tree-lined frontages on the western edge, it's important it also has a countryside abutting it in the form of undeveloped arable fields. The appeal site is one of those fields. What is more, the nature of the appeal site, the undeveloped arable nature of the appeal site, is readily perceptible from users of the A131 and visitors to High Garrett. As the LVA recognised, and as will have been evident from the site view, clear views into the site are offered, specifically towards the south of the site. Whether walking or driving along the A131, one cannot help but to appreciate the appeal site, together with Thistle Field to the south, remain undeveloped agricultural fields. The same is true, of course, when walking the public right-of-way that runs through the north of the appeal site. Now, the appellant variously describes High Garrett as having a semi-rural or peri-urban character, the latter evidently meaning rural-urban transition. Now, even assuming Miss Brockhurst is correct to suggest that these terms are not synonymous, with peri-urban being slightly more urban than semi-rural on the continuum of rural to urban, it's clear that whatever categorisation is used, in such locations there will be found some elements which are of a rural character and some elements which are of an urban character. The appeal site is the former. In its current form, it forms a rural element which contributes to the semi-rural, peri-urban character of High Garrett. It counterbalances the urban elements, particularly the busy A131 and the existing built development, particularly that to the east of the road. It is this counterbalance which gives High Garrett its semi-rural or peri-urban character. Indeed, the appeal site plays an important role in this regard because, as Miss Brockenhurst points out herself in her proof, open areas are not common features alongside the A131. If development of the appeal site is permitted for 37 homes, it will have an adverse landscape effect, not only on the field itself, as the appellant accepts, but also on the character of High Garrett. It will further urbanise the settlement and remove an important contributor to its currently semi-rural or peri-urban character. The impact on the character of High Garrett is harmful in its own right, but it will have the added impact of reducing the distinct identities of High Garrett and Bockham. As it currently stands, travelling from north to south into Braintree via Bocking, there is a gradual transition from countryside to town. The A13 runs through countryside to north of High Garrett. High Garrett itself is of a semi-rural character. Bocking is of a different suburban character, and finally Braintree an urban character. Thus they are experienced as distinct settlements, each having a different character. The adverse impact that development have on the character of High Garrett, causing it to become more urban and less rural, will reduce the difference in character between Bocking and High Garrett and make more abrupt the transition from countryside to town. If this development goes ahead, a person travelling north to south will find it harder to distinguish between the settlements of Bocking and High Garrett if the development, if we delete if the development. So I should say, actually, if this development goes ahead, a person travelling north to south or south to north would find it harder to distinguish between the settlements of Bocking and High Garrett. Finally, the Council acknowledges, and has always acknowledged, it's something that was addressed in the officer's report, that the landscape capacity study concludes that the parcel of land, which includes the appeal site, has a medium capacity for development. This does not mean the development will cause no harm in landscape terms, as the appellant acknowledges. Indeed, the findings of the capacity study have to be seen in context. Firstly, it was a finer-grained assessment of areas in the districts which had already been identified as having a low or low to medium capacity to absorb development. And secondly, the conclusion that parcel 13A had a medium capacity development was, unsurprisingly, the middle of the range of capacities that the study employed. None of this marks the appeal site out as having a especially suitable location for development in landscape or visual terms. Still less does it suggest that harm caused would necessarily be limited. Visual harm. So you'll assess the degree of visual harm that would occur from the development proposals, drawing no doubt on your own observations from the site visit. The Council accept the visual harm will be localised. That is not to say that it should be ignored. Adverse visual effects will be experienced by users of the A131 on foot or in vehicles, adjoining neighbours, and the users of the public right-of-way. Conclusions then on this topic. The adverse landscape and visual impacts of the scheme render the proposal in conflict with development plan policy. Because it fails to recognise the intrinsic character and beauty of the countryside, and in particular the function played by the countryside in this location, it's also inconsistent with national policy. The landscape and visual harm that would be caused and the consequential breach of the policy weighs significantly against the proposal in the planning balance. Fourthly, the topic of housing land supply, and I start with a general approach to the assessment of 5-year housing land supply. As was submitted during the roundtable session, there are some important points of principle which must be kept in mind when assessing the deliverable supply. Firstly, the test of realistic prospect. The definition of deliverability in the NPPF requires, amongst other things, that there is a realistic prospect that housing will be delivered on site within 5 years. As was confirmed by the Court of Appeal in the St Modwin judgment, the question is not whether the housing in question will be delivered within 5 years, nor is it whether it will be probable or more than likely that the site will be delivered in 5 years. The threshold is lower, whether there is a prospect of it being delivered within that time frame and whether the prospect is realistic. And so, as I haven't been reading out the footnotes, otherwise we would be here all day. But just to highlight, in the St Modwin case, it was being argued there in terms that in order to have a realistic prospect, it needed to be shown that it was more likely than not. And that was expressly rejected by the Court of Appeal, as I detail there, and as is evident from the judgment, which is in the court documents. Secondly, categories A and B. The categories A and B, which are added to the 2019 version of the NPPF and remain in the 2021 version, are not exhaustive. They're not a closed list, as the appellant accepts. Nor do they change the test to be applied. They are evidential presumptions, but those presumptions have to be read in light of and be consistent with the operative test to be applied, including the meaning of realistic prospect. Thirdly, what is meant by clear evidence? It says sites fall within category B should only be considered deliverable when there is clear evidence that housing completions will begin on the site within 5 years. And so the focus of this evidential presumption is simply on whether housing completions will begin on site within the 5-year period. Moreover, as the inspector in the Linton Way inquiry has recently observed, the phrase will begin does not mean, nor cannot mean, there needs to be a certainty of housing completions starting on site within 5 years. A degree of probability is to be expected. And so I submit that must be correct when it's remembered that the operative test only requires a realistic prospect that housing will be delivered. Fourthly, clear evidence. What are the sources of that evidence? There are no, we submit, hard and fast rules as to what constitutes clear evidence. It is entirely context specific. The planning practice guidance outlines some examples of clear evidence, but they are not exhaustive. And the apparent suggestion by the inspector in the Little Sparrows appeal decision that there is necessarily some bright line rule, which means that clear evidence necessarily requires more than securing an email pro forma from developers or agents as to the projected delivery, must be rejected. There is simply no basis for that approach in planning policy, guidance, or indeed common sense. So I turn then to the council's position and the evidence. The council can demonstrate a 5.2-year deliverable supply of housing. And that is, so as I state there, including meeting requirement, which includes both the requisite buffer, but also addressing all of the shortfall from the base date of the plan period on a sedge-filled basis, i.e. all of it within the first 5 years. Our evidence for supporting that position is contained within Mr Evans's proof, the council's response to the Station Road decision, and our submissions on the inquiry documents 47. And most importantly, perhaps, it's supported by Mr Evans' oral evidence during the roundtable sessions. Now, so I don't repeat that evidence here. Instead, what I do is attach to this closing a brief summary of the headline points in respect of each of the disputed sites. I don't intend that, sir, to replace the detailed evidence which you've already heard on the deliverability of the sites. It is just an aid memoir, as it were. I don't intend to read that out either, unless you require me to, sir. Sorry, so you're on mute there, but I think.
Apologies. Yes. No. Just please carry on with your closing statement.
I've seen actually Mr. Easton has done something very similar in his closing as well. There are no new points in that, obviously. Paragraph 84. 2 overarching observations on the council's evidence of deliverability must be made, however. First, the council have taken a conservative approach to the assessment of deliverability in a number of respects. This includes not only by including sites. This includes by only including sites in the deliverable supply where they had permission at the base date or a resolution to grant the base date with subsequent grant of permission. And just pausing there, so you'll know that categories A and B conceive of sites being classified as deliverable which don't have permission. And secondly, on a number of occasions, they've taken a more cautious approach than the developers' agents have in their projected supplies, in respect of at least 5 of the sites in dispute. And we do say that is relevant because it sets the context for the assessment which is to be undertaken by you, sir. Secondly, I say this as a noticeable feature of this inquiry. It was clear from the evidence of Mr Evans, both orally and in writing, that he and his colleagues have an extremely detailed knowledge of the sites in question, as well as the context of housing delivery in their area more generally. This is not a case where local authorities relied on the word of the agents and developers without more. They have scrutinised the evidence concerning each of the sites carefully and in great detail in order to reach a considered judgment as to whether there is a realistic prospect that housing will be delivered within 5 years. And if so, how much? Given that context, it's respectfully submitted, sir, that you should be slow to depart from the judgments reached by the council concerning the deliverability of the sites within that area. But just on that, sir, I'm not seeking to suggest that it's not for you to come to your own judgments about deliverability. You're not performing a review exercise in court, as a court would do, for instance, on applying a public law standard. But I do suggest that given the context of this case and given the detailed consideration given by Mr Evans and his colleagues, that it's an appropriate case where you should pay due regard to that detailed assessment and the knowledge of the officers of their own area and the sites within their area, and be cautious about departing from their judgments. I make it plain, so I do not make that submission in each and every case I appear where 5-year supply occurs. I make it in this case because of the knowledge of Mr Evans and his colleagues and the detailed examination that they have undertaken. Thanks, sir. Turning then finally to the planning balance, and I start with the benefits. Now, it's acknowledged there are benefits from the appeal scheme. Those benefits are those to which are to be expected from a proposal for residential development of this scale. There is nothing out of the ordinary. That is not to downplay the benefits, it's simply a statement of fact. Chief amongst the benefits is the delivery of market and affordable housing. In terms of market housing, the housing and supply position of the council is healthy. It has on its case a 5-year supply of housing. But even if the appellant's case is accepted in full, any shortfall could not be described as significant, as Mr Murray Cox accepted. As, if not more importantly, the council is at an advanced stage with its Section 2 local plan, through which housing needs 2033 are to be exceeded. As noted above, this is a robust supply with a significant majority of the allocated sites already having received planning permission. It is accepted there is a need for affordable housing in the area, and that there has been a shortfall in supply since the base date of the Section 1 plan. However, in the last 2 full monitoring years, the council has exceeded the affordable housing requirement, and in the current monitoring year, the council has already exceeded the affordable housing requirement in the first 6 months. It projects a delivery of 424 affordable homes this year, twice the annual affordable housing requirement. In addition, as Ms Banks explained, the council are committed to addressing the overall shortfall in housing, which has accrued since the base date, within the first 5 years, i.e. it applies the central approach. This already being factored into the 5-year housing land supply calculations. This will bring with it significant affordable housing delivery to address the accrued shortfall. Now, the appellant seeks to make much of the fact that there's been no affordable housing completions in High Garrett itself in the recent past. This is both unsurprising and unremarkable. It's entirely consistent with the fact that High Garrett is an unsustainable location for significant development, it being national policy that affordable housing should not be sought from developments of less than 10 homes. This is not to say that affordable housing will not be delivered in the area to meet needs. Within the Bocking North ward, the area within which the ward within which High Garrett falls, there are a number of large allocations which already have planning permission that will deliver a significant amount of affordable housing. Taking all this into account, the delivery of market and affordable housing should be given moderate weight in this context. The remaining benefits of the proposal are at most of limited weight. The economic benefits are a consequence of the delivery of housing rather than as being separate from it. And this is not a strategic site which will bring with it significant economic benefits in one stroke. The landscape improvements must be seen in the context where it is agreed there will be a net adverse effect in landscape terms. And the highway benefits, such as the provision of pedestrian crossings, are necessary mitigation. They will provide limited, if any, material benefit to existing residents. Turning then to the balance. The proposal is contrary to the spatial strategies and policies of both of the existing and emerging development plans. But this is unsurprising, given that, as the evidence this inquiry has shown, High Garrett in general, and the appeal site in particular, is a wholly unsustainable location for significant development. This renders the proposal fundamentally in conflict with the development plan as a whole, as well as in conflict with national policy. It is common ground the proposal would also have an adverse impact on landscape character and visual amenity. Whether you agree with the council or the appellant about the degree of that harm, this too is a fact which must weigh against the proposal. Set against this, the relatively modest benefits of the proposal do not come close to outweighing the breach of the development plan and the harm that the proposal would cause. Even if the tilted balance is engaged, even if that's because you find there's a lack of 5-year supply or the most important policies are considered to be out of date, the adverse impacts of the proposal, which include its conflict with the development plan, significantly and demonstrably outweigh the benefits of this scheme. In conclusion, therefore, it follows from the above that the material considerations do not outweigh the breach of the development plan. Accordingly, the council, sir, invite you, applying section 38(6) of the 2004 Act, to refuse planning permission and to dismiss the appeal.
Thank you, Mr. Williams. Mr. Easton, do you wish to make the closing statements on behalf of the appellant?
I do. Thank you very much indeed, sir. So I'll keep mainly to my text, but at certain points I need to depart to respond to some of the points my learned friend made in closing, but I will give you due warning so you can take a note. The appeal scheme should never have been refused by the council. It's in a location where the council's evidence base expressly states that residential development would form a natural extension to High Garrett. It provides more than adequate opportunities for people to travel to everyday services and facilities by sustainable mode of transport. Development of the appeal site will assist in boosting the supply of housing, whatever the current 5-year land supply position is. Crucially, affordable housing will be delivered for those in genuine housing need. At its heart, national policy seeks net environmental, social and economic gains. the appeal scheme delivers against these critically important objectives. It was perhaps in belated recognition of the acceptability of the appellant's proposals that the council's case disintegrated during cross-examination of Mrs. Banks. The concessions she made hold the local authority's case below the waterline. And so, as my learned friend did, and as I did an opening, the structure of these closing submissions follows the issues that you alighted upon in your note. I don't read them out. I also explain that paragraph 4, housing land supply is addressed primarily in an annex to these closing submissions, which, like Mr. Williams, I don't propose to read out. So I turn to the first issue, suitable location for housing. This issue essentially is focused on the national and local policy context, but it also speaks to a broader question. If the council is to meet its housing land requirements and deliver homes for people in genuine housing need, how and where should that occur? One sometimes loses sight of that wider question in favour of a legalistic and forensic analysis of development plan policies. Sadly, the council's consideration of the appeal scheme is a prime example of not seeing the wood for the planning trees. It is critically important this appeal is determined within the correct decision-taking framework. Central to the council's case is its continued and stalwart reliance on adopted development plan policies which seek to restrict development which lie beyond outdated settlement boundaries. This, we say, is an entirely misguided approach, and one that will condemn the council to missing out on its obligation to facilitate the delivery of housing for those people in need. The approach to interpreting planning policies has generated much litigation since the publication of the framework in 2012. There is unlikely to be much between the parties as to the correct approach, which is set out in Canterbury City Council against the Secretary of State. I simply draw your attention, sir, in closing to the following principles. First, there is clear distinction to be drawn between the interpretation of policies, a legal question, and their application, which is a matter for the decision taker, for you, sir. Second, one should not engage in linguistic gymnastics to force a particular meaning of a policy. One's reminded of the famous words of Lord Reed in the case of Tesco against Dundee, that planning authorities do not live in the world of Humpty Dumpty. They can't make the development plan mean whatever they would like it to mean. We should have Lord Reed's speech firmly in mind when considering the council's approach to policy SP3 of the Part 1 local plan in particular. Third, whilst policies must be read in their proper context, which does include their objectives and the supporting text, it is the policies themselves which form part of the development plan and which guide decision making for the purposes of section 38(6 of the Planning Compulsory Purchase Act. The case of Bassett law against the Secretary of State neatly encapsulates the correct approach, and so I don't read out the entirety of the quote. You've got the judgment. I just thought it'd be helpful if you had the relevant paragraphs of the judgment before you, but I do draw attention to paragraph 16, which I have extracted, which says, therefore, whilst the stated aims or objectives in a neighbourhood plan, and this applies equally to a local plan, may cast light on how the policies in that plan are to be interpreted, they're no substitute for the policies themselves, and the fact that a proposed development is assessed as being contrary to the objectives stated in the neighbourhood plan doesn't mean that it conflicts with the plan itself. In the present case, that difference is of some importance. And I say, sir, as was the case in Bassett law, the difference between the aims and objectives of policy SP3 and its explicit wording may be of some importance. So paragraph 12. There is no argument from us, sir, that the adopted development plan represents the starting point for you. We also concede that the appeal scheme runs contrary to policy RLP2 and policy CS5 by virtue of its location outside settlement boundaries that were fixed long before the framework and well in advance of the council setting an up-to-date housing figure for the area. Any breach of these policies should attract only limited weight given the lack of a 5-year land supply, the fact that the current boundaries do not reflect current housing need, and the council's extremely heavy reliance upon housing sites which sit outside settlement limits. Indeed, the clear inference is that the council itself recognises these boundaries and the policies which protect them are no longer fit for purpose. In cross-examination, Mrs. Banks accepted that the weight to be attached to RLP2 and CS5 should be reduced to reflect the fact that, firstly, the boundaries do not reflect current development needs, and secondly, that the council's housing land supply relies on schemes contrary to RLP2 and CS5 that were permitted on appeal. Thus, the issue is not whether the weight of these policies should be reduced, it is by how much they should be reduced. Mrs. Banks held on to moderate weight, but for reasons that are all too apparent, this was a dramatically optimistic assessment. So can I just pause there for a moment to respond to a point that Malone Firm makes at paragraphs 24 and 31 of his closing submissions. Mrs. Banks was clear as to the reasons why she reduced the weight to policies RLP2 and CS5, and I've explained that in paragraph 12. At paragraphs 24 and paragraph 31, Malone Friend seeks to elevate the status of the emerging local plan part 2 as a reason why weight should still be attached to the settlement boundary policies. So the question for you with respect is whether the current adopted development boundaries are sufficient to meet development needs. They don't, and that is one of the reasons why Mrs. Banks accepted that moderate weight should be given to conflict with policy. I'll make a follow-up point to this effect, that the local plan strategy part 2 is not part of the adopted development plan documents for the purposes of section 38.6. It has not yet been found sound by the inspectors examining it. It is currently going through the main modifications process, following which representors will be entitled to make their views known about a variety of different matters, including the ability of the council to demonstrate the deliverability of its claimed supply. So it's for that reason, amongst others, that Mr. Murray Cox, quite properly in my submission, said that only limited weight should attach to the local plan strategy part 2. So I revert now to text paragraph 13. Both policies RLP2 and CS5 are predicated on strict control of development outside settlement boundaries in order to protect the character of the countryside, a relic from the days of PPS 7. In evidence in chief, Mrs. Banks claimed that the appeal site falls outside the High Garrett settlement boundary and, I emphasise this, as such, fails to protect and enhance the character of the countryside. This evidence was telling. Mrs. Banks appears to have been alighted upon the expression in, not CD5, so it should be CS5, forgive me, the expression in order to protect and enhance landscape character. However, the phrase in that policy is essentially redundant, since it is an explanation of the purpose of the policy, rather than a specific consideration to see whether a particular scheme meets the terms of the policy. Put another way, CS5 seeks to protect landscape character by restricting development only to countryside appropriate uses. It is simply impossible for any form of inappropriate development to bring itself within the scope of CS5 by showing that there is no harm to landscape character. This binary and highly restrictive effect of the policy clashes with the framework in a startling fashion for 3 reasons. Firstly, the effect of CS5 is to provide the same level of protection from inappropriate development to all areas of land outside settlement boundaries, irrespective of their landscape quality or sensitivity. The MPPF does not throw a protective blanket over all areas of countryside. Second, there is nothing in the framework that justifies the severe restriction on development outside settlement boundaries, which the core strategy and the rather aged local plan imposes. And thirdly, even the purpose of the policy, avoiding any harm to landscape character, goes beyond the scope of the framework. There is a difference between recognising the intrinsic character and beauty of the countryside and protecting it. The former objective denotes a lesser level of harm avoidance than the latter. By prohibiting any harm, CS5 equates all areas of land outside settlement boundaries with valued landscapes, and see paragraph 174 of the framework. For these clear and compelling reasons, CS5 is jarringly inconsistent with the framework, such that it should be considered to be out of date and of only limited weight. Equally importantly, given that Mrs. Banks accepted correctly that policies RLP and CS5 are the most important policies for determining the appeal, Paragraph 11D of the framework is triggered and the tilted balance engaged whether or not the council is able to demonstrate a deliverable housing supply. These conclusions are not controversial, nor are they novel. They are consistent with a number of previous inspectors' analysis. So I don't propose to read those out. Gilder Terrace, Old Hall, Coggeshall and Landoff Church Street. Those you have the references and you have the core documents. Consequently, whatever the housing land supply position, two conclusions follow. Firstly, policies RLP2 and CS5 are inconsistent with the framework. And secondly, as the most important policies for determining the appeal, their inconsistency triggers the tilted planning balance. Further, conflict with these policies should attract only limited weight. I turn now, sir, to the vexed question of policy SP3. We have no doubt that Council seek to argue that policy SP3 of the Part 1 local plan is an overarching strategic policy intended to guide the policies and allocations in the Part 2 local plan, and so we were right. That would, however, be only a small part of the picture. Discussion on the interpretation of this policy during Mrs. Banks's cross-examination was particularly illuminating. First, SP3 is relevant to development management decisions. That much was apparent from Mrs. Banks's answers, but was underscored by express reliance on SP3 and the reasons for refusal. The local planning authority chose to rely on SP3, which runs entirely contrary to any notion that it's relevant only as a strategic policy to guide plan making. If it has the meaning offered by the local planning authority, there'll be little point in relying upon SP3 and the reasons for refusal, or spending so much time during the inquiry seeking to argue that it only has a strategic function. Second, the starting point must always be the wording of the policy itself. SP3 contemplates development within or adjoining settlements. As a matter of fact, it's common ground that the appeal site adjoins the settlement boundary of High Garrett. As part of the adopted development plan for Braintree, one looks to the adopted local plan, which does have settlement boundaries in it, to see where they are. These boundaries must endure for the duration of the plan period to 2033. In other words, they must be fit for both allocations in the Part 2 local plan and for decision taking, whatever those settlement boundaries look like. So far, and as Mrs. Banks accepted, the appeal scheme does not conflict with policy SP3. Third, and as the Gilder Terrace inspector quite properly recognised, the permissive approach of SP3 does not provide free rein for all development outside settlement limits. SP3 contains a number of development management principles that are directed at preventing unacceptable proposals both within and without settlements. The first and second paragraphs of the policy refer to the scale, sustainability and role of the receiving settlement and to the need to maintain the distinctive character of settlements. These objectives will prevent the free-for-all that the Council seems particularly concerned about. In fact, as Mr. Murray Cox observed in Evidence in Chief, policy SP3 is progressive, since it steps back from the binary options enshrined in policies RLP2 and CS5 and recognises the more nuanced approach in national policy. Having analysed SP3 correctly, it was no surprise that Mrs. Banks accepted that there could be no in-principle objection to the appeal scheme, and the compliance with the development management objectives will ensure compliance with the policy as a whole. As such, and importantly in this case, SP3 is the real touchstone for assessing the suitability of the appeal site. Fourth, in evidence in chief of Mrs. Banks and cross-examination of Mr. Murray Cox, we were taken to various parts of the explanatory text in the Part 1 local plan, some of the text being some distance from the policy wording itself. As the Bassett Law judgment confirms, this explanatory text cannot alter the policy itself. Paragraph 3.2 of the Part 1 local plan refers to main settlements and strategic scale new development. In fact, all that paragraphs 3.2 to 3.6 of the Part 1 local plan provide is the spatial context of the North Essex area, rather than attempt to provide any gloss on the policy wording. Mr. Murray Cox was taken to paragraph 1.9 of the plan, which states that central to this sustainable growth strategy is the effective delivery of should be planned strategic growth, particularly housing. Apparently this text, which we say does no more than explain the need for a strategic approach, confirm that SP3 is a strategic policy designed to inform the Part 2 local plan. That is a step way too far. If policy SP3 was meant only to apply in limited circumstances, the policy should have said so. It does not, and it is wholly impermissible to attempt to place a gloss on or effectively amend the wording of the policy in that way. In cross-examination of Mr. Murray Cox, but not in Mrs. Banks's written or oral evidence, reference was made to paragraph 1.13 of the Part 1 local plan, which sets out the main purposes of the strategic chapter of the local plan. References are made to a strategic vision for how planned growth will be realised. This doesn't advance matters at all. Even if the strategic policies are intended to show how planned growth can be delivered, it is only one of the main purposes, not the only purpose. However, and more fundamentally, these purposes simply cannot alter the plain and ordinary meaning of policy SP3, which is the local planning authority's obvious intention in this case. Next, nowhere in the wording of SP3 is the meaning of the word settlement circumscribed by reference to main settlements or strategic scale new development, which is the inference that the local planning authority invite you to draw, sir. Similarly, there's nothing in the policy that restricts its application to plan making and allocations. Such an interpretation would in any event emasculate the policy and place a meaning on it that it couldn't possibly bear. Whatever aim or objective the Council believes SP3 to have, it does not explicitly form part of the policy itself. Finally, the interpretation of SP3 presented by the Council ignores the fact that the policy itself must endure for the plan period to 2033, including after the adoption of the Part 2 local plan. The Council's approach suggests that once the Part 2 local plan is adopted and allocations made, SP3 essentially becomes redundant because it will have served its strategic purpose. There is nothing in the policy wording or the supporting text which indicates that policy SP3 is time limited in this way. And I do say that, sir, that this is not an obvious consequence of the Council's interpretation of policy SP3 with which my learned friend grappled in his closing submissions. So, having properly understood the meaning of policy SP3, the following conclusions emerge. SP3 is the most up-to-date part of the development plan which addresses the suitability of the appeal site for development. To the extent that it conflicts with policy ROP2 and CS5, which it obviously does, Section 38.5 of the 2004 Act dictates that SP3 should take precedence. Indeed, this further reduces the weight to be given to RLP2 and CS5. Thirdly, there can be no in-principle objection to the appeal scheme by virtue of its location outside the settlement boundary of High Garrett. And fourthly, if the appeal scheme meets the development management objectives in policy SP3, it will meet the requirements of SP3. In this sense, the suitability of the appeal site will depend on your judgment, sir, in relation to issues B and C, accessibility and character and appearance. The appellant's interpretation is not only consistent with the plain and ordinary meaning of policy SP3, but it also aligns the policy with a more nuanced assessment required by the National Planning Policy Framework. It also avoids the carte blanche for all development outside settlement boundaries about which the Council appears so concerned. Importantly, it avoids entirely acceptable proposals such as the appeal scheme being refused planning permission merely because they sit on the wrong side of a line drawn on a proposals map. So I turn next to emerging policy. The Council has set great store by policy LPP1 of the Emerging Local Plan Part 2. As Mrs. Banks confirmed in cross-examination, although LPP1 seeks to confine development outside settlement boundaries to uses appropriate in the countryside, the aim of the policy is broadly the same as existing policies RLP2 and CS5. In other words, to restrict development and to protect land outside settlement boundaries, irrespective of its landscape value. Consequently, for the reasons already outlined above, and as concluded by a number of other inspectors, policy LPP1, if adopted in its current form, would be inconsistent with the framework, which does not throw a protective blanket over all areas of land outside settlement boundaries. Paragraph 174B of the framework requires decision takers to recognise the intrinsic character and beauty of the countryside, which denotes a more subtle and sophisticated approach than the in or out stance that Braintree has consistently adopted through policies RLP2 and CS5, and which it proposes to continue with its new local plan Part 2. Moreover, there is no evidence before the inquiry as to how the inevitable tension between policy SP3 and emerging policy LPP1 will be resolved. They will be part of the same suite of development plan documents, but poll in opposite directions. If only for this reason, limited weight should be afforded to LPP1. It is not an adopted policy. Whatever the council might say about the local plan inspectors approving main modifications for consultation, that consultation has not been completed. Representatives have not yet all submitted their responses, and the inspectors have not ruled on the soundness of LPP1. Even if they had, it still remains open to you, sir, consistent with others who have considered RLP2 and CS5, to find that LPP1 is inconsistent with the framework for the reasons already set out. So I turn to the conclusions in relation to issue A. Given the proper interpretation of policy SP3, the location of the appeal site is in principle a suitable location for residential development. The acceptability of the current proposal within the terms of SP3 depends firstly upon its accessibility to services and facilities, and secondly its effect on landscape character and visual amenity. But whether the appellant is right or wrong on the interpretation of policy SP3, policies RLP2 and CS5 are out of date and should attract only limited weight, certainly insufficient weight to establish an in-principle barrier to development of the appeal site. So I turn next to accessibility. At its heart, the aim of national transport policy is to reduce the negative environmental and public health effects of travel. As Mrs. Banks accepted, if a scheme aligns itself with that objective, it is likely to be sustainable. And it's important to note that national policy does not demonise the private car. On the contrary, car sharing and low or zero emission vehicles are expressly included within the definition of sustainable transport modes in the framework. The appeal scheme will facilitate and support these modes. These measures will deliver the national policy objective before one even considers walking and cycling distances or the proximity of buses and the frequency of their services. So can I just depart here and respond to a point that my learned friend makes at paragraph 55 of his closing submissions. He there refers to provision of broadband and electric vehicle charging points as an addition, somehow reducing their value as a sustainable travel option, particularly electric vehicles. So that would be a misunderstanding of national policy. Paragraph 110 of the framework establishes the need to ensure that appropriate opportunities to promote sustainable transport modes can be taken up. So I'll pause there for a minute. If at any point I'm going too fast for your note, just raise your hand and I'll slow down. Electric vehicle charging points are consistent with this paragraph 110 objective, as well as being consistent with paragraph 112D of the framework. Learned friend's submission also misses the broader point. Sustainability of a location is not a tick box exercise, but requires an overall judgment as to whether the policy tests in paragraph 105 and 110 of the framework are satisfied. Within this overall assessment, the provision of electric vehicle charging points is part of a package of sustainable transport modes. I should make it clear at this point, sir, that it's never been the appellant's case that the availability of one sustainable transport mode can make an otherwise unsustainable location sustainable. It's an overall assessment, sir. So I return to my text at paragraph 35. The framework speaks of providing a genuine choice of transport modes and maximising sustainable transport solutions. Those are the requirements. It's not a requirement to limit car use to an absolute minimum or eliminate it altogether. Before addressing the detail, we should compare and contrast the evidence presented to this inquiry. Whilst Mrs. Banks is undoubtedly an experienced planner, she is not a highways engineer or an expert in sustainable transport. That doesn't mean she's not entitled to express an opinion, but in the present case, her evidence must be given substantially reduced weight. It is abundantly clear that Mrs. Banks's view on the bus services wasn't actually based on the accessibility of the crossing point. In cross-examination, she stated that even if the crossing point were replaced with a controlled signal crossing, people would still prefer to use a private car as opposed to the bus or to public transport in general as a result of, I quote, human nature. Mrs. Banks's approach, which significantly reduces any positive consideration of accessible public transport, is fundamentally flawed, is at odds with national policy, which aims to provide opportunities for sustainable transport modes. It also speaks to her general approach to this topic. Mr. Grist, on the other hand, is a recognised expert with many years of relevant experience. His evidence was clear, cogent, and when presented with an apparent flaw, he accepted it and reflected on whether it would alter his overall judgment. That speaks to his impartiality and credibility. Insofar as there is any dispute between Mr. Grist's and Mrs. Banks's evidence, Mr. Grist's should unquestionably be preferred. It's also important to note that no professionally qualified transport planner considers that the appeal site is unsustainable. Essex County Council's development management team's professional transport planning officers assessed the site and found it to be sufficiently sustainable. Despite the County Council's conclusions, Braintree, through Mrs. Banks, has reached the opposite judgment. And as we shall see, that judgment, Braintree's judgment, is unfounded. So far as walking is concerned, there are two elements to this, quantitative and qualitative. I deal first of all with the quantitative assessment. The distance between the site and local facilities is agreed. Similarly, whilst the local planning authority take the point that High Garrett itself does not have a range of services and facilities to meet everyday needs, they did not seek to maintain that the locations shown in the Statement of Common Ground appendices could not meet those needs. There is no policy or guidance as to reasonable walking distance in the framework or the planning practice guidance. Accordingly, Mr. Grist has relied on guidance documents, including the IHT guidance and Manual for Streets. The applicability of such guidance hasn't been disputed by the Council, even though Mrs. Banks did not refer to all relevant evidence and guidance. Some little time was spent in cross-examination and, dare I say it, in closing submissions as well, in forensic dissection of the IHT guidance and the National Travel Survey, as well as references to the Manual for Streets that didn't even warrant a mention Mrs. Banks's written or oral evidence. With the exception of one concession regarding school trips, Mr. Williams's gallant efforts didn't make a dent in Mr. Grist's central thesis, which was that a holistic assessment of the relevant evidence and guidance leads one to the conclusion that a walking trip of around 2 kilometres is a reasonable walking distance. It was never Mr. Grist's case that any one piece of guidance or evidence was determinative, but that awareness of the guidance produced a more rounded overall assessment. That is exactly what Mr. Grist provided. Mrs. Banks, on the other hand, concentrated almost exclusively on the IHT guidance. However, she was forced to accept that she'd misinterpreted it. Anything above the acceptable category in Table 3.2 would not be walkable, according to Mrs. Banks. However, all categorised distances from desirable to acceptable, and including the preferred maximum, are indeed acceptable. That much is apparent from the heading of Table 3.2. Accordingly, Mrs. Banks accepted that the primary school, located at a walking distance of 1,990 metres from the appeal site, is at a reasonable walking distance. Mrs. Banks also accepted in cross-examination that she failed to take account of the Manual for Streets guidance that walking trips of up to 2 kilometres offer the greatest potential to replace short car trips. The Manual for Streets reference carries through the well-known former policy advice in PPG 13, which advice was based on empirical evidence, not conjecture. The National Travel Survey, which indicates how far people actually walk, further supports Mr. Grist's approximately 2 kilometres assessment, since it shows that approximately 1/3 of one-way, I underline that, journeys are between 1 and 2 miles and they are undertaken on foot. All of the considered day-to-day facilities situated in Bocking are approximately 2 kilometres, and therefore, on the basis of Mr. Grist's sensible and well-explained assessment, are within a reasonable walking distance. We're therefore left with Mrs. Banks's characterisation of the walk to Bocking as intimidating. Mrs. Banks accepted in her evidence that the County Council highways have not raised any issues with regard to highway safety, but that a number of factors would operate as disincentives for pedestrians. She also accepted that the reference to pedestrian safety in reason for refusal 1 should be removed. That concession was rightly made, given that there's no evidence whatsoever of any personal injury accidents along the A131 or any accidents involving cyclists for that matter. None of Mrs. Banks's factors bore any scrutiny. First was narrowness of the pavement. Mrs. Banks did not measure the width of the pavements, but Mr. Grist did. They ranged from 1.7 to 2.4 metres, which is sufficient at its narrowest to allow a wheelchair user and a pedestrian to pass. In evidence in chief, Mrs. Banks made reference to the poor state of repair of some of the footways, but agreed in cross-examination that the County Council, as Highways Authority, have an obligation to maintain and repair the footpaths, and that one must presume that this will be met. The next factor was amount and speed of traffic. Mrs. Banks appeared to rely upon her impression rather than any empirical evidence. As Mr. Grist quite rightly pointed out, the A131 is an arterial route into a main town with a level of traffic flows that one would expect for such a road. It isn't unusual or especially busy, certainly not enough to put people off walking. There is a 40-mile speed limit, so the vehicles will be travelling at that speed, should be or less, not of less. The A131, as Mr. Grist observed, is not a fast road. Mrs. Banks accepted in cross-examination that the traffic on the A131 is nothing out of the ordinary compared with other routes with a speed limit of 40 miles an hour. It is common to many urban environments. Noise. The appellant produced an acoustic design statement which confirmed that the external noise environment will be acceptable for gardens of the majority of proposed dwellings. If future residents will not be disturbed when using their gardens, it's extremely difficult to believe that they will be dissuaded by road noise from walking to the local shops or to school. The final factor was fumes. The A131 in this location does not form part of an air quality management area, and the council did not require an air quality assessment with the proposal. Significantly, as Mr. Grist observed, the route to Bocking is relatively open, thereby avoiding the funneling effect that a more built-up area might produce. None of the factors that underpinned Mrs. Banks's qualitative review stand up. As such, her case on walkability must fall down. But that isn't the end of the matter. There is street lighting along the whole of the walking route, further minimising any perception of risk to personal safety. Similarly, there are good sight lines along the walking route, ensuring good visibility between pedestrians and drivers. There is good surveillance from existing houses along almost the entirety of the route. And finally, none of the features that may give rise to a safety concern, such as blind corners, are present in this case. Alternatively, there is also a public right-of-way, which, although further in distance, provides a more attractive route away from the road that certain residents may choose to use. We accept entirely, of course, that this option might be taken up by fewer residents, but it's an opportunity consistent with national policy nonetheless. Both the distance and the quality of the route to local services and facilities are sufficiently acceptable. We repeat the point that it is not a requirement of national policy that everyone will walk to Bocking, but rather it's an option as part of a package of sustainable transport modes. Bus services. In cross-examination, Mrs. Banks accepted that the bus services are close to the site, that there is a good level of bus services, not reasonably good as found its way into the closing submissions of my learned friend. There's a good level of bus services for residents. In particular, there are 3 buses per hour, with a journey time of 3 to 4 minutes to Bocking and 9 minutes to Braintree. This is a better frequency of service than in many urban areas. Further, Mrs. Banks agreed that upgrades to bus stops would benefit both future and existing residents. there is and can be no quantitative objection in relation to access to bus services. Mrs. Banks's only disagreement in relation to the accessibility of bus services was in respect of crossing the A131 to access the southbound bus stop. She agreed that the northbound bus services are easily accessible. However, it's abundantly clear that Mrs. Banks's view on the bus services is not actually based on the accessibility of the crossing point. She stated in cross-examination that even if the crossing point was replaced with a controlled signal crossing, people would still prefer to use the private car or to public transport in general as a result of human nature. So I turn to paragraph 54. In any event, Mrs. Banks's evidence only assessed the current crossing and completely failed to consider the positive impacts of the appellant's proposed improvements. In cross-examination, Mrs. Banks agreed that an uncontrolled crossing point recently implemented in High Garrett, similar to that proposed as part of the development scheme, was safe. A similar design would further facilitate the crossing of the A131, albeit that it is already safe, for pedestrians and existing residents, both for those intending to walk and those intending to use the bus services. Finally, for exactly the same reasons as Mrs. Banks's disincentives to walking were wholly misguided, so was her single point of objection on bus accessibility. Cycling. There's little between the parties as to the possibility of residents being able to cycle from the site should they wish to do so. Indeed, Mrs. Banks's objection does not fundamentally contradict the appellant's submission. Confident cyclists can reach the whole of Braintree Station and other wider destinations within a 20-minute cycle ride. Mrs. Banks subsequently agreed in cross-examination that cycling ought not to be discounted as a possible sustainable mode of transport. We accept entirely that the number of people cycling is unlikely to be the majority. The percentage of people in Bocking North Ward, 2%, is in line with the national statistics. Cycling is therefore a realistic and an accessible mode of sustainable transport for consideration as part of the package. Other forms of sustainable transport. As we know, sir, the glossary definition of sustainable transport modes includes ultra-low and zero-emission vehicles. Mrs. Banks accepted in cross-examination that she failed to consider electric vehicle charging and that it does meet the objective of paragraph 105 of the framework. Cross-examination, Mrs. Banks also accepted that she failed to consider car sharing, a further sustainable mode of transport that could be encouraged through a travel plan. And similarly, and this speaks to the broader objective of reducing the need to travel, fibre optic broadband facilitating home working will be delivered as part of the proposal. Braintree railway station is within 5 kilometres of the site, enabling access from cycling, as there are cycle parking facilities available, or by bus. Therefore, travel to the station for onwards travel by rail can be made sustainably. The above considerations were not, but ought to have been, taken into account and factored into the sustainability of the site and the benefits of the development. All are in the appellant's favour in complying with national policy. I touch briefly, sir, on the principle of consistency of the council's approach to other sites in High Garrett. Mrs. Banks agreed in cross-examination that paragraph 110 of the framework applies to any development, irrespective of its size. As such, even small schemes must be judged by reference to the sustainability of their location. Mrs. Banks's apparent view that High Garrett itself is not a sustainable location for growth should therefore be read in conjunction with the council's decisions in respect of other sites in High Garrett, an approach accepted by her in cross-examination. And so paragraph 64, I just draw your attention that you have the evidence already in relation to other decisions which conclude on the sustainability of High Garrett. I don't propose to read them out. Neither, sir, do I propose to read out all of the conclusions in relation to acceptability, save to note this at the beginning of paragraph 65. The appeal site is accessible by a real choice of sustainable modes of transport in compliance both with local and with national policy. So I turn to issue C now, so landscape and visual impact. It is a trite point that the construction of any number of houses on a greenfield site will change its landscape character. However, this change in character must be seen against the backdrop of government policy, which seeks to boost significantly the supply of housing and which does not require the avoidance of all harm to the countryside, as the predecessors to the NPPF did. It is inevitable that there will be some level of adverse impact from the grant of planning permission, but that should not automatically lead to the refusal of planning permission. If it did, Braintree Council's housing supply would be dramatically reduced and no meaningful response to the housing crisis could ever be provided. As the inquiries progress, it's become extremely difficult to understand the Council's case on this issue. References to coalescence were jettisoned by Mrs Banks during cross-examination. Reliance on a gap proved to be misguided because Mrs Banks was apparently referring to the gap between Bocking Church Street and High Garrett, a total irrelevance in this case. We are now seemingly left with an allegation that the appeal site forms part of the setting of High Garrett and as an undeveloped arable field provides some form of relief from built development. This lack of specificity and clarity does the Council no credit, but certainly underlines the weakness of its objection. That Mrs Banks was singly unable to marshal a convincing case is not at all surprising. While she was entitled as a planner to offer an opinion on landscape impacts, it conflicted with the views of not one, not two, but 3 independent assessments carried out by appropriately qualified landscape architects. Whilst the Council's Landscape Services Department did not make any assessment per se, they offered no objection, presumably because they couldn't sustain one. The landscape capacity analysis produced for the Council is a crucial piece of evidence. As Mrs Brockhurst observed in evidence, it was produced before and outside the cauldron of a planning inquiry, and as such is especially independent. The analysis, is unusual in the size of the assessment parcels and the level of detail into which it descends. Perhaps most importantly, not only was it produced to inform the plan making of Local Plan Part 2, but the Council will be directing applicants and decision makers to take it into account in individual applications. And so I'll give you the extract there, paragraph 8.26 of the Emerging Local Plan, which states that it is necessary on individual applications to take into account the landscape capacity analysis. Even Mrs Banks accepted that the role of the capacity analysis was to provide an evidence base and assist in the landscape evaluation of applications. The appeal site is within the relatively small parcel 13A of the fine-grained study. Parcel 13A was identified as being of medium capacity for development. Read in context, there were only 2 parcels that were identified as being of greater capacity, both categorised as medium-high, and only 19% of the parcels overall were identified as being medium or higher. Quite properly, the officer's report recognised that a site with medium capacity is, I quote, most likely to be suitable as a location for development. We accept entirely that a finding of medium capacity for development is not determinative, but it's a powerful consideration in favour of the appeal scheme. Of equal, if not greater weight, is the professional assessment in the text of the capacity analysis. Once one considers the careful way in which parcel 13A is assessed, the Council's case crumbles. First of all, development within the parcel would form a natural extension to High Garrett. This is a telling and arguably determinative conclusion which should have carried considerable weight in the Council's decision making. Is consistent with the Tyler Grange landscape and visual appraisal and with Mrs Brockhurst's own professional judgment. Next, the change in topography to the west provides separation between the parcel that is connected to High Garrett and the sloping arable farmland that adjoins it. At this point, any vestigial case that the appeal site performs an anti-coalescence role simply dissolves. Thirdly, these factors in the existing landscape framework present good scope to provide landscape mitigation in the medium term. The reference to mitigation presupposes that residential development will be present on the appeal site. This mitigation will be provided as part of the landscape-led design of the proposals before you, sir, bringing the appeal scheme directly in line with the capacity analysis. Despite having no landscape qualifications, Mrs Banks disagreed with the conclusions of the expert study. Nonetheless, she did concede in cross-examination that her conclusion in respect to the role that the site plays in the landscape was reached without an evidence base or character assessment offering sufficient justification. It was also accepted that she hadn't carried out an assessment of the magnitude of change or sensitivity of receptors. Accordingly, Mrs. Banks agreed in cross-examination with the study's conclusions that it is the change in topography to the west of the site that provides separation between the site that is connected to High Garrett and the sloping arable farmland. There was no concern expressed about coalescence or the lack of separation in the study, and Mrs. Banks agreed that the site does not play a role in marking the transition from Bocking or Braintree, as the site is definitively within High Garrett. At that point, can I just depart for a moment? At paragraph 74 of my learned friend's closing submissions, he refers to the reduction in the distinct identities of High Garrett and Bocking. That is a coalescence argument. As we know, sir, any coalescence or gap argument was abandoned by Mrs. Banks in cross-examination, and in any event is not supported in any way, shape or form by independent analysis of the role that the appeal site plays. So paragraph 75. It was also accepted by Mrs. Banks in cross-examination the site doesn't form part of any green buffer existing or emerging. The council actually has a draft green buffer policy, but the appeal site doesn't fall within its purview. The site, in fact, the site is not within or even adjoining land considered to provide a buffer function. Accordingly, that Mrs. Banks's view of the role of the site as expressed in her proof of evidence is no longer applicable, which therefore invalidates her assessment. The opinions expressed by Mrs. Banks are not only inconsistent with a document the council considers to be relevant to decision taking, but are also in stark contrast to the careful, clear and convincing assessment that Mrs. Brockhurst offered in her written and oral evidence. Mrs. Brockhurst was an impressive and persuasive witness whose expertise was plain to see. She explained, before considering any evidence base or other background documents such as capacity analysis, she reaches her own view. That's the way she works. In this case, Mrs. Brockhurst's view about the value of the appeal site and the role it plays aligned with the conclusions reached by her fellow landscape professionals. In closing, we can do no better than repeat Mrs. Brockhurst's conclusions, all of which remain as valid now as when she wrote her proof of evidence. That's just a ready reckoner and a good summary, sir, as to Mrs. Brockhurst's position. I don't propose to read it out. So paragraph 78. Before turning briefly to consider visual impacts, we should address what remains of the council's case, that the appeal site forms part of the setting of High Garrett. This objection is entirely devoid of any recognisable methodology and is wholly unsupported by the capacity analysis, the landscape and visual appraisal, the council's own landscape services, Mrs. Brockhurst, or any policies or landscape character assessment. In substance, the council is asking you, sir, to conclude that an ordinary green field within a peri-urban context should be protected from any built development because it's undeveloped. This is a weak argument indeed. As Mrs. Brockhurst explained, the appeal site is not in the countryside. One's sense is of being on the edge of an urban area or moving through it on the A131 rather than being an open countryside. The appeal site may be undeveloped, but its function is not one of providing relief or a setting to a settlement that has no discernible central core. And I depart once more, sir, to respond to what my learned friend says at paragraph 73 of his closing submissions, where he claims that development would remove an important contributor to its currently semi-rural or peri-urban character. So there are 3 points in response to that. Firstly, the peri-urban character is precisely why the capacity analysis concluded that the parcel 13A would form a natural extension to the existing settlement. Second point, the important contributor argument does not arise out of anything in the evidence, most importantly, the capacity analysis. And thirdly, I ask rhetorically, where does this point end? Because exactly the same argument could be made in respect of any greenfield site on the edge of a settlement, thereby preventing development simply because it is a greenfield on the edge of a settlement. So back to the text, paragraph 79. In any event, the appeal scheme will be designed and laid out in such a way as to be characteristic of the area, with a strengthening of the western boundary and planting along the A131. The elements will be entirely consistent with the greener western side of the A131, which includes Grove Fields. In this way, the setting, such as it is, and to the extent that it needs to be recognised, will be respected, and that relief from the hard urban edge on the eastern side of the A131 would be maintained. So visual impact. Mrs. Banks's evidence made reference to the views from the A131 into the countryside beyond the site and behind Grove Field. In cross-examination, however, she agreed that Mrs. Brockhurst's photo montage demonstrated that there is no intervisibility between the countryside and the site. In any event, Mrs. Banks also accepted that the council would have control over any landscape management conditions, whereas currently there is no mechanism of control. It follows that such management would both be positive and beneficial in landscape and visual impact terms. So we say limited, if any, visual impact. Without prejudice to the above submissions, if you do conclude, sir, that there would be changes in views, such changes would only be experienced from a very localised area, predominantly immediately adjacent to the site. So I complete this topic by reference to the fact that Mrs. Banks didn't include any of the relevant benefits. There are a number of benefits that ought to have been and ought to be taken into consideration. There's the retained vegetation and maintenance of the field pattern, along with management of the existing tree stock to ensure its lifespan is maximised, reinforcement and enhancement of wooded qualities with new tree and hedgerow planting, ecological enhancement measures providing for damp grassland and occasionally wet areas, meadow grassland and new linear corridors to facilitate greater connectivity and movement between off-site habitats, and the provision of open space and enhancement of recreational provision in the settlement, including the formalisation and management of the informal footpaths which have been created by the existing community through trespass. So that leads to the following conclusions on this topic. So we invite you to adopt the findings of the 2015 expert study, the landscape and visual appraisal, and Mrs. Brockhurst's careful assessment. The development would form a natural extension to High Garrett. There will be a change, and it is likely to be adverse taken in the round, but the development will be a well-integrated extension to High Garrett within the existing settlement. The appeal scheme also offers substantial benefits. Set against the independent assessments carried out by qualified experts, Mrs. Banks's was a lone voice of objection based on opinion and conjecture rather than any evidence-based documents or policy justification. Mrs. Banks did her best to defend the council position, but had few tenable or coherent arguments. The expert evidence has 3 times supported the appeal site as a suitable location for development. The expert evidence has 3 times demonstrated that residential development would not come close to breaching the threshold of unacceptability. Issue D, housing land supply. It's important to observe that the council, so before I start, so can I just make a brief response to something my own friend says about 5-year land supply at his paragraph 81. I'm sure he doesn't mean it in this way, but at paragraph 81, he makes reference to the claimed 5.27-year deliverable supply, including the requisite buffer, as well as addressing shortfall on a Sedgefield basis. I'm afraid the council doesn't get any extra credits for including a buffer or making up a shortfall within the 5-year period. They are policy requirements. The council supply is the supply. There is clear agreement as to the requirement and also as to the application of the buffer and the period within which any shortfall ought to be caught up. So I revert to my text. So it's important to observe that the council's housing and land supply position has consistently been very fragile, and where it has exceeded 5 years, any excess has been extremely marginal. It's therefore unsurprising that less than 3 weeks ago, an inspector examining substantially the same evidence base as at this inquiry concluded that the housing land supply ranged between 4.7 to 4.9 years, sufficient on either basis to tilt the planning balance. That decision, the Station Road decision, is an important material consideration that you ought to follow, we say, sir. It's a recent decision that interrogated the same housing land supply statement as we considered during this inquiry, and Mr. Evans was the witness who presented evidence for the local planning authority. So I just depart there for a moment. Mr. Williams places reliance upon Mr. Evans's experience and his detailed assessment. One should presume that that same level of detailed assessment was provided at the Station Road hearing. Notwithstanding that, the Station Road inspector rejected the council's argument in respect of sufficient sites to reduce the housing land supply to below 5 years. So I revert to text. Mindful of the need for consistency in decision taking, if you decide, sir, to adopt a different conclusion, which of course is your entitlement, we don't encourage you to do that, then clear reasons should be given for that difference in judgment. However, as I say in the text, we're confident it won't be necessary for you to grapple with that particular issue in this case, sir. There is complete agreement as to the housing requirement. The question is whether the council can demonstrate a deliverable supply, in particular whether it can provide clear evidence for those sites where there isn't a presumption of deliverability. Interestingly, since the proofs were exchanged, the council have reduced their surplus from 371 to 336 to 286, a clear downward trend. So just to focus the debate, and you'll see from the annex that is exactly what I've done. If you conclude that the appellant's judgment is to be preferred in respect of 286 dwellings, there will not be a 5-year supply. And it is equally notable in this regard that a significant proportion of the council's claim supply arises from planning permissions granted on appeal. As I say in 87, sir, the position is well known. Now you have a clear note of the exchanges during the round table session, which we summarise mostly in the annex. So having looked at all that and reviewed the evidence and the submissions, we are entirely confident that you will feel compelled to deduct at least 286 homes the council's claim supply. That will be sufficient to tilt the planning balance through the application of paragraph 11D of the framework. So I turn to the final issue, which is the planning balance, including benefits. So before I address the planning balance, this seems to be the most convenient place to address two outstanding matters, which are not issues between the parties, but are matters that you, sir, have to consider. First, we accept that there will be less than substantial harm, albeit at the lowermost end of the spectrum, to the listed mill lodge through development within its setting. The council, despite resting its case on the landscape setting of High Garrett, doesn't consider that any heritage harm will arise. Mr. Murray Cox's clear evidence was that the public benefits of the scheme would outweigh the less than substantial harm to Mill Lodge. That's an application of paragraph 202 of the framework, which policy test is satisfied. And so you rightly drew Mr. Murray Cox's attention to your statutory duty under section 66 of the Listed Buildings Act. And the legal position, we say, is quite clear. If you, sir, work through the policies in the framework relating to designated heritage assets, then you will in substance comply with the statutory duty under section 66. So I don't know whether I've given you the case, and I've also given you the paragraph reference in Jones and Mordew. I hope that's sufficient in the circumstance. Of course, if there's anything else you want me to take you to, then I'm happy to do so. But we say you can be quite satisfied that both the statutory and the policy test in relation to designated heritage assets are satisfied in this case. The second outstanding matter relates to habitats. The appellant carried out a shadow habitats regulation assessment to show that with the payment of appropriate contributions secured with the Section 106 obligation, there would not be an adverse effect on the SBA Ramsar site. This is agreed, and I've just extracted for your convenience the relevant paragraph in the Statement of Common Ground, which confirms that is the case. So I now turn to the planning balance. There are a number of approaches, each of which we say should result in planning permission being granted. The first one is, given the inconsistencies between RLP2 and CS5 and the more recent SP3, the appellant's primary case is that policy SP3 should take precedence. Given that SP3 involves an assessment of accessibility and impact on character and appearance, acceptance of the appellant's case should lead to a conclusion that the appeal scheme complies with the development plan and that permission should be granted without delay. The finding of development plan compliance doesn't require an assessment of the housing land supply, nor does it involve consideration of whether RLP2 and CS5 are consistent with national policy. The next basis is the tilted planning balance. In this case, there are two triggers: inconsistency of RLP2 and CS5, the most important policies, with the framework, and or the lack of a deliverable housing supply. In this scenario, the imperative to grant planning permission remains, and any conflict with the development plan must be judged by reference to whether the adverse impacts significantly and demonstrably outweigh the benefits. And the third option is the even planning balance. This scenario presupposes that there is development plan conflict, but the scales are evenly weighted because you don't trigger the planning balance by reference to inconsistency with the framework, or you conclude that there is a 5-year supply. So I turn to the benefits. During inquiries, it's natural to focus on what is apparently wrong with the scheme, given that the issues tend to be framed by the reasons for refusal. However, this approach sometimes risks underplaying the benefits of development, and for local authorities, as here, to argue that the proposal is just a run-of-the-mill housing development, nothing special. That fundamentally misses the point. National policy tells decision makers to help boost housing supply, to support small and medium-sized builders, and to give significant weight to economic growth. If the run-of-the-mill argument gains traction, then it's difficult to see how these national policy objectives will be met, since the benefits of residential development are likely to be minimised. This is of great concern, since national policy is seeking to respond to the social and economic challenges brought about by the country's long-standing housing crisis, exacerbated by the COVID-19 pandemic. At its most basic level, our case is that the social, economic and environmental benefits of this appeal scheme will not come forward if permission is refused. It is those benefits which should be weighed in the planning balance, and their weight should not be reduced merely because similar benefits could be produced on a site elsewhere in the district. That argument risks becoming circular, so that the benefits of straightforward but sorely needed housing schemes are reduced. The Council's case on landscape impact provides an interesting counterpoint. The authority have elevated the value of an undesignated ordinary field, which would form a natural extension to the existing settlement, to a precious resource that ought to be protected come what may. However, they downplay the benefits because they are ordinary. This is a wholly inconsistent and unbalanced approach. Council's stance is continued and replicated, and Mrs. Banks's view that all measures secured by the Section 106 agreement are required as mitigation and are therefore neutral in the planning balance. It would appear that her argument extends also to conditions. That's simply wrong, as Mr. Murray Cox explained in evidence in chief. It's true that planning obligations must be necessary to make development acceptable, but in many cases mitigation will bring forward collateral benefits to the local area and for existing residents. For example, the financial contributions towards open space will not only benefit future residents of the appeal scheme, the upgraded bus stops and new pedestrian crossings will not be for the exclusive use of future residents. The maintenance and management of the green infrastructure will deliver biodiversity benefits and a wider public interest. It would therefore be misguided to discount the many collateral benefits that will be brought forward through conditions and planning obligations, as Mrs. Banks has done. The Council's evidence not only takes a logically incorrect approach, but dramatically undervalues the benefits of the appeal scheme. Although it will not strictly be necessary to address the benefits of the appeal scheme if it complies with the development plan, those benefits are nonetheless many and compelling. Significant weight should be afforded to the provision of 37 homes in an area where the council has consistently been unable to demonstrate a 5-year supply of housing land. So we remain firmly of the view that significant weight should still attach to the delivery of market housing, even in the unlikely event that the council can show a 5-year supply, even if they can, a supply of, and that should be 5.27 years, is marginal. National policy is clear. Housing requirements constitute a minimum figure, and there remains a continuing obligation to boost housing supply. So next, the council's track record in bringing forward affordable homes is lamentable. Mr. Murray Cox's unchallenged evidence is that there's currently a shortfall of 587 affordable homes since the start of the local plan period. As Mr. Murray Cox quite rightly says, it isn't simply a numbers game. The accumulated shortfall represents 587 households in genuine housing need, who remain in genuine housing need because insufficient homes have been provided. These are real people who've been unable to access affordable housing. The position is made even more stark when one considers that there were 2,464 households on the council's housing register as at the 1st of April this year. That's an astonishing number, which underscores the need to grant many more planning permissions, such as the appeal scheme, that can deliver affordable housing in short order and provide people with the homes that they need. Locally in High Garrett, there have been no affordable homes built this century. How, we ask rhetorically, are the children of current residents going to afford their homes in the place they grew up unless more planning permissions are granted which include affordable housing? So the local planning authority claimed that, so it's 400, I put 408 because that was my note originally, but I do appreciate that the council's bumped up its projected delivery to 424. That makes no difference to the point I'm about to make. The council claimed that 424 affordable homes will be delivered in 21-22, setting aside for one moment the late introduction of this point and the appellant's inability to interrogate the data that lie behind this claim. The construction of 424 homes will not eliminate the current shortfall and will get nowhere near clearing the huge waiting list. Given that none of those homes will be delivered in High Garrett itself, the ability for local residents in affordable housing need to live in suitable accommodation will remain a pipe dream. In the circumstances, the only tenable conclusion is that significant weight must be given to affordable housing. Next, the introduction of an economically active population and the creation of additional jobs will represent an important boost to the local economy. These economic benefits, which don't appear to be challenged by the council, should weigh heavily in favour of the appeal scheme, especially where the council is not delivering the level of economic growth that should go hand in hand with a deliverable supply of housing. This latter point should add weight to this particular benefit, since the absence of a 5-year supply results in an imbalance between the number of workers required to deliver economic growth and the homes to accommodate them. The council's failure to facilitate housing delivery will necessarily exacerbate this imbalance, which can partially be redressed by granting planning permission for sites such as the appeal site. Next is the provision of bus stop upgrades, pedestrian crossings and a footway for the benefit of future and existing residents. The provision of open space and the enhancement of existing recreational provision. These facilities will not be for the exclusive use of future residents and will consequently bring with them benefits for the wider community. And so there'll also be a series of landscape benefits, which I've outlined previously in these closing submissions. The approach to landscape management accords with the objectives of the landscape capacity analysis and self-evidently has value beyond its role of mitigation. Allied to these landscape benefits will be the delivery of biodiversity net gains, a central objective of government policy. The appeal scheme will undoubtedly produce net positives in respect of the social, economic and environmental aspects of sustainable development taken in the round. To that end, it aligns itself closely with one of the most fundamental aims of national policy. Even if the appeal scheme runs contrary to a number of development plan policies, any such conflict should be afforded limited weight in light of the fact that the district settlement boundaries are not fit for purpose. The considerable benefits of the proposal, seen in the light of the government's target of addressing the current housing crisis, substantially outweigh any negative impacts. So whether the tilted balance applies or, contrary to our case, the scales are evenly weighted, the positive effects of this appeal scheme far outweigh the very limited harm. And so it's for all of these reasons, as well as those given in evidence, we invite you to grant planning permission subject to conditions and an executed planning obligation. And so, as I said, the rest of these closed submissions include an annex, which I don't propose to read out. So unless I can assist you with anything else, those are my closing submissions. Thank you.
Thank you, Mr. Easton. Thank you to both advocates for those closing submissions. Okay, I'm now going to move on to cost applications. In relation to, firstly, whether there are any applications for costs. Firstly, the council.
No, sir.
And the appellant.
Not from us, sir. Thank you.
Well, I think we're now moving to the point where I will close the inquiry. Thank you all for your contributions. Again, as on previous days, can please the completed attendance sheets be forwarded on to my case officer. As I say, thank you for your contributions, and the inquiry is now closed. Thank you.
Thank you very much, sir.
Very much, sir.